I awakened and did my work, and then I went back to sleep. What's going on with those instructions?
Judge, if I could, initially I was hoping that the court would take up our motion for reconsideration, which was filed a week ago Monday.
Right.
And once that's done, depending on how you rule on it, I would have an objection to 2176 because in my reading of 2176, the notes set forth what is to happen or how the court is to do it when there is an alleged exception, which we are alleging here. And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And the response is that I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week. Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to, I looked at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation or the forfeiture action alone, and I can just tell them I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. If it's not the subject for a motion to dismiss, the complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually get the complaint dismissed. If they wish to present a case, if they wish to raise an affirmative defense, which is that he was compliant under both of those subsections, that if he had a hunter safety permit or the certificate of completion that the second part of that, third part of that statute calls for, they can do so. But until they do that, I don't see why that should be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly will attempt to do so, then it can be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I didn't know I have to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of the curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
You don't think I can just pick a 12-person jury to decide it?
Well, it's a different standard of proof.
Using.
Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause, we've met our standard in the complaint, and it's been bound over. And now it's up to the defense if they want to try and raise this affirmative defense. We disagree that being 17 in and of itself raises an affirmative defense, the state believes he'd have to present the certificate of completion of a hunter safety permit as called for in the statute. Thank you.
Okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those. Well, I don't know if and that's probably not the best thing to do either, because then they don't know what we're talking about. What's your reaction to the claim that it's an affirmative defense?
It's not an affirmative defense. For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court through the legislative history makes it clear it's an exception. It's not an affirmative defense. It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places it tells you in plain language that it does not apply. Not for hunting purposes, it does not apply, period, to 16 and 17-year-olds who possess firearms. That is, and I provided that to the court both in the Act and in the Senate bill, Judge, and in the Legislative Reference Bureau information.
Well,
So,
I'm going to give the instruction as I've stated it. These are educational. They don't get a written copy, and they're just so they know what we're talking about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which you shouldn't assume. But if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other. But no matter what it is exceptional from the general language of the statute.
And Judge, I'm not going to argue with you about it. It makes it a strict liability offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
Unless he has the
No.
That's the last part of the statute. In Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17...
That's how you read it.
But it's not how we
That's
He
how
reads
the
it
DNR
differently.
That's how the DNR reads it. And
Ah,
that's how they cite it.
Yeah, okay.
So in
all
16
right.
and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
Yeah, well.
And that's being completely ignored in Mr. Trofsky's argument.
Okay. I am going to give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay. And the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't they have a general instruction on self-defense?
You listed them specifically for the charges or for the counts?
Did?
That's what I saw.
Boy, it was early this morning. It says counts 1 through 5. Oh, no, that's not it. You're right. let's see, count 5 is attempt to commit murder. That is going to have the same self-defense instruction as count. One, 3, and 4.
Very good. I just wanted to make sure that.
You were correct in your observation.
Well, you tell me when you're ready, Judge.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count 2? Count 2, I'm sorry, 820. During instruction 820 is mentioned in there. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first
And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee, was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the jury to consider in determining whether his conduct was criminally reckless, and also was a factor for them to consider in determining whether it was done with utter disregard for human life. That's how I read it. I certainly don't think I would want to get, you could put a law school test together on this, you know? But that's how I read it. Now tell me where you think I'm in error.
Well, I'm not saying you're in error. I'm saying that I think if he's in self-defense as it relates to Mr. Rosenbaum, according to this, according to 820, he then has a perfect self-defense. If the defendant was acting in self-defense, his conduct did not create an unreasonable risk to another. So,
well, wait a minute. Let's give a situation where I'm out on the street and somebody confronts me, and there's a family of 4 little children right behind him, and the other person, the other actor, puts me in, I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone, the danger zone is not only the actor with whom I have a perfect self-defense, privilege of self-defense, but also the 4 children who are behind him. And I think this is how I reconciled that reading in my mind, was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless with respect to those children, and also whether it was showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot wouldn't have the children in the background. That's how I reconciled it. But I agree with you, it's confusing.
Because I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says. So I don't think then.
Well, why do they, I'm sorry, go ahead.
No, so I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then there's a period. So.
Well, why does it say up above that in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said to you.
No, what you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't, you're telling me there's an absolute privilege of self-defense, not only as to the bad actor, but also as to the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense. That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another. Period.
If you look at the comments from the instructions committee, on page, well, I don't know if you've got the pages there, but well, I have them, but near the end it says, for example, assume that a defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is There is not a, what you're arguing, I think, becomes a perfect self-defense as to injury to others during the exercise of perfect self-defense, and I don't think that's the law. It maybe was what we once thought, but I don't think it's the law now, and that the jury, when they approach the McGinnis case, looks at whether the defendant, even if exercising perfect self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was, if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it, and that's how I'm going to say it. But I am going to, I'm going to try to skirt around those sixth and seventh counts because we don't have an instruction for number 7, and number 6 is. I've had lots of statutory issues come up over the years, and this is the knottiest. Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me, Judge.
State?
No.
Okay. Let's get the jury down.
Your Honor, before you do that, Your Honor, I do want to put something on the record with regard to the jury.
Oh, yeah, I got something here, too. Yeah, what's up?
Your Honor, at the end of the proceedings last night, Brian Stute from our office came in to begin the process of setting up the audiovisual equipment and whatnot. While he was, I think, entering the courtroom from the hallway, he passed by one of our jurors. And I'm going to identify this juror as Juror 52. I can say more about that person's identity, but I don't want to do it openly in court. My understanding is that Juror 52 recognized Mr. Stute, said something like, hey, how you doing? Like they knew each other. And I think Mr. Stute responded, politely in response, and that was the extent of their interaction. Mr. Stute has explained subsequently that he had a previous employment where he remembers Juror 52 from, and so that's the extent of their prior knowledge of one another. So I wanted to lay that on the record so that everybody is aware of that. I did tell counsel about that this morning before we went on the record as well.
All right. Any question or observation?
Judge, do you feel the need to ask her if that would have any impact on her ability to serve?
I don't. You can ask you can ask me to ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have a question about the accuracy of the report to me. I think it's a non-issue.
That's fine, Judge. We are ready to go forward.
Splendid. Okay, anything else? And I did get a note. Do you know from whom this came? Well, I don't know which one, though.
She didn't put a turn number on there?
this only suppress the sound while I hold it down, or does it click on and off? Press. And then if I put, and now I'm live again, right? Okay, I've got the nice hand signals here from the respectful hand signals from the Court TV crowd. Thank you.
It's on the back.
I agree with your observation. Okay, you know what? Give them to the.
I'm guessing.
Okay, well, I guess too, but. Okay, let's ask the lawyers to come up, please. Huh? What did he say?
Sure.
Okay. Make a copy of both sides and then pick it back up, please. All right. I'll wait long enough for that to happen. You know what? She can. You can give it to her when she comes down. All right.
Hello?
Would you come down, please?
You got it.
Thank you.
We need the door open. I don't know if somebody's standing over there or not.
One to a chair, please.
No, we're not using those. We're just using this area. One person can still sit up there. And then push that chair back. No, yep.
Oh, okay, good. Thank you very much. Well, give one each side. Okay, there we go. Oh, wait a minute, my response isn't on there. Is my response on the ones you've got there?
No.
Okay. Give each side, if you can hunt it down, the photocopy of, with my response. Make a copy for each side, and then we'll take care of it. You can be seated. Good morning, everyone.
We'll just one. The gentleman with the scooter.
Okay, and then we have to swear the jury.
Yep.
All right. Maybe you can. The building is almost 100 years old. We're going to have our 100th anniversary, I think, the year after next. And then the chair is original equipment and some of the furniture here. And then can you move that, which is the most comfortable location? Would it be comfortable down there? Right there in front of the officer there?
We'll
Well-
just have to move the chair.
Yeah, well, that might, will he be able to see everything from there? That's my only concern.
Your Honor.
Okay, yeah,
I just want to put the TV right in front.
okay, perfect.
So, okay.
All right, great. I'll talk more about the building later. And that chair, when there's a break, we're going to move that out of there because I don't think I like it there. Yeah.
Did you fill in the sandwich?
I did, and I gave it to Tim. Thank you. And that can go to the, thank you. And then one of these to, okay, one of those to each side when there's a break or something. Good morning, everyone, and I'm glad I told you not to come in until 9:45. I did tell you that, didn't I? Oh, okay. All right. No, we were doing some legal stuff, and that happens periodically throughout the trial, and it's nothing exceptional. In fact, it usually ends up saving some time, some of your valuable time, and so we hope Oh, I see how it's laid out. Okay. We hope won't have too much more of that today. Would you? We're going to swear you now, your oath, to reach a fair and just verdict. So, if you would please,
Can I
Mrs.
ask
Lehman.
all the jurors to raise their hand, please, to take the second oath? Do you and each of you swear that you will well and truly try the issue joined between the state of Wisconsin plaintiff and Kyle Rittenhouse defendant, and unless discharged by the court, a true verdict give according to the evidence given in court, so help you God? And
Please silence those phones if you would, if you've got them on an audible signal. And before the trial begins, I want to give you some instructions which I hope will help you better understand your functions as jurors and how you should conduct yourselves during the trial. Your duty will be to decide the case solely as the evidence develops, presented at the trial, and the law is given to you in my instructions. Anything that you see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all of the evidence has been presented and I have instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to discuss legal matters with the attorneys that do not necessarily concern you, or in some cases, if something needs to be discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, it might be a little bit tight, but I think you'll be okay. And otherwise, we may take a break, and you'll be up in your jury room. When you're in the jury room, you need to stay there. You can't be wandering the hallways. You can't be coming and going, except when you have permission from the bailiffs. And you do have, if you have permission from the bailiffs, you may go to the break room across the hall here, where they've got some vending machines. You can also go outside if you want to get a little fresh air, or smoke if that's what you want to do. The bailiffs will escort you, so you need to go as a group, and they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day. Do not research any information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial. Do not consult dictionaries, computers, websites, or other reference material for additional information. Do not seek information regarding the public records of anyone involved in this case. Any information that you may obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial has been completed, you are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I am not indicating any opinion about the value of that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may rely upon, after the trial, your notes will be collected and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily upon your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness has an interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice, if any is shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant the third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male, and to each of these charges as well the defendant has pleaded not guilty. Reckless endangerment of the first degree, as charged in these counts, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. A great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to determine intent, which must be found, if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be Intent should not be confused with motive. While proof of motive is necessary to a conviction, while proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first-degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The sixth count charges that at the same time and place the defendant was a person under the age of 18 years and was armed with a dangerous weapon. The seventh count charges that at the same time and place the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts. The first 5 counts of the information allege not only that the defendant committed the crimes which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called upon to answer it, then you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove, by evidence which satisfies you beyond a reasonable doubt, that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and attempted intentional homicide. A separate instruction applies to, I'm sorry, I misstated that. The reckless, the instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count, and that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way acting with aggression towards him. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who was in the area of the gunfire. And so you have to analyze that separately and determine, well, I'll get further into it. And keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. We're going to hear the opening statements of the lawyers now. And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement. The argument is for the end, and that's when they're going to make their pleas to you to return verdicts in accordance with their beliefs. At this point, they're going to briefly acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence, and they can be very useful to you for those purposes, and they're brief. And then we can right into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state, and then Mr. Richards will have the opportunity to make an opening statement now, or if he prefers, he is entitled to reserve his opening statement to a later point in the trial. And with that, again, no note, well, you haven't got the papers yet anyway, but no note-taking now because this is a discussion by the lawyer. But please give them your attention. And with that, Mr. Binger, you may proceed.
Thank you, Judge. Good morning, ladies and gentlemen. The evidence in this case will show that on the night of August 25th, 2020, here in our community of Kenosha, the defendant, Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine. And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man. The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15. The evidence will show that the defendant fled the scene of the dead body of Joseph Rosenbaum without stopping to offer any aid whatsoever. And as he's running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant. One person hits him in the back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber. Eventually, the defendant loses his balance and falls to the ground. An individual who is the subject of count number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face while the defendant is on the ground. This unknown individual is unarmed. The defendant, in response, points his AR-15 directly at this individual as this individual is literally flying over his body and discharges that gun twice. Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe and perhaps even fatal. Immediately after that, Anthony Huber, who is holding a skateboard, comes in and reaches for the defendant's gun. He grabs hold of the gun and tries to pull it away from the defendant. The defendant is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body, and the gun is slung from that, so it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly. A final individual by the name of Gage Grosskreutz has followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand. He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand. The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the photos and the videos, that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand. And as he's reaching for the defendant turns the AR-15 and discharges the 8th and final round into Mr. Grosskreutz's right arm, the arm with the gun. Mr. Grosskreutz runs off, screaming for a medic. The defendant gets up and walks away. On that night, he killed 2 unarmed people, shot at a third at very close range, and wounded Mr. Grosskreutz in the arm, who was armed with a gun. It is the state's position that this evidence demonstrates the criminal charges against the defendant: his intentional homicide of Anthony Huber and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here. As we all discussed yesterday, this occurs during the context of the events following the shooting of Jacob Blake, which occurred on Sunday night, August 23rd, 2020. And we all know that within a short period of time after that, the community erupted in protests, looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street, the furniture business there, Car Source, one of their locations on Sheridan, and other properties around town that were damaged. Fortunately, in the entire sequence of events, this was all property damage. And one of the things we all agreed on yesterday is life is more important than property. Up until Tuesday night, despite all the things that the community had experienced, no one had been killed. But what happened as the time went on was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community were drawn to the chaos here in Kenosha. People from outside of Kenosha came in and contributed to that chaos. And it caused many of our citizens to fear for their safety, fear for their homes and their families, fear for their businesses, and take steps to protect themselves, whether it is to arm themselves, board up their windows, move, or take time away from the community. All of those reactions were entirely understandable and reasonable. And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue. But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant, Kyle Rittenhouse. The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle Rittenhouse. We will show you videos of some of the events that night, of police, tear gas, rubber bullets, and yet the only person who killed anyone was the defendant. There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire throughout our community that night. Hundreds of people are there experiencing this, and yet the only one who kills anyone is the defendant. We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces. And yet the only person who killed anyone is the defendant. Hundreds of people experienced those nights, experienced the night of August 25th, experienced that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle Rittenhouse. Recently, I heard someone sort of tongue-in-cheek joke that jury service is bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gage Grosskreuz's arm. That will not be in dispute. The central issue in this case is going to be self-defense. And the judge has given you an instruction, which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case. The defendant used deadly force. There is a privilege under our laws to use deadly force, but it's a very limited privilege. That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not with the benefit of hindsight. You are essentially the people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant to believe that the force was necessary to prevent imminent death or great bodily harm to himself? So, let's talk about the context of that evening. And I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence as it comes into this trial. The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th, 2020. In fact, on May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun. And so this was, in effect, a straw purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And they fire both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range that they have on that property. And Mr. Black will tell you some more about that. Then they agreed that that gun would not go home with the defendant to his home in Antioch, Illinois. It would stay here in Kenosha at the residence of Dominic Black's stepfather in a locked gun case. And in fact, after the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th, 2020. On the night leading up to August 25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would do something about what was going on in Kenosha. So one point earlier in the day, they come down here. They work on cleaning up some graffiti on some buildings here downtown. Then they decide they want to come back later that night and protect a local business, a business called Car Source, which is located at 59th and Sheridan. Now, as I talked to you a little bit about yesterday, Car Source actually has 3 locations very close in this downtown area. One of them was on the east side of Sheridan Road at 58th and Sheridan. And either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out. The building itself was damaged as well. Right across the street from there is another Car Source location that also sold used cars. And some of those cars had been damaged on the night of Monday, August 24th. So on Tuesday, when the defendant and Mr. Black are out and about, they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and the defendant go out to Jelinski's out on Highway 31, Green Bay Road. And they acquire straps so that they can sling those guns around themselves when they come back to the downtown area that night. And eventually later that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location, and protect that location to make sure no one damages the cars, no one damages the property. And I want to be clear, there's nothing wrong with that. Protecting that property is entirely lawful, totally understandable, and it's something that many people here in Kenosha did. And there's a group of people, including the defendant and Dominic Black, that take up positions at 59th Street. Some of them, like the defendant, are on the ground in the parking lot, where as people are walking by on the street, they're having interactions with these people. Dominic Black will testify he took up a position on the roof. He did that because he didn't want to be on the ground, close to where other folks were, close to where potential issues might arise. He wanted to stay a little bit removed from all of that. Didn't want to get directly involved in it. You will hear and see videos of sequence of events going on around Kenosha that night. The evening begins with large-scale protests, large-scale, no other way to put it, rioting that's occurring right outside these windows, right in front of the courthouse here at Civic Center Park. There is a crowd of police that have lined up to protect this building, to protect the public safety building, which is right next door. And there are a large number of protesters that are agitating. They are screaming at the police. They are throwing projectiles. Police are shooting rubber bullets, tear gas, etc. It is a very volatile situation at Civic Center Park. Now, that's at 56th and Sheridan, about 3 blocks north of the car source where the defendant was. But as the evening goes on, the police decide to move the line of protesters south on Sheridan. And eventually, they pass the car source at 59th and Sheridan. The police establish a line at 60th and Sheridan, 1 block south. Now, as that process is going on, many of these protesters pass by the defendant and the people that he's with at 59th Street. Words are exchanged. There is confrontation. There is a little bit of hostility. No one is hurt. No one fires a gun. No one is injured. But clearly there's antagonism. It is clear that this is a crowd that is not on the same side as the defendant, that does not see him as an ally, does not see him and his group as someone that they identify with. And as I said, there is a hostile exchange there for a while. In fact, at one point, members of the crowd pull one of the dumpsters from the property out into the street and attempt to start it on fire. And some of the other folks that are there with the defendant go out and put the fire out and have some very harsh interactions with those people in the street. I believe the evidence will show that it is this process that demonstrated for the defendant that this is a crowd that is not a safe crowd to be in. This is a crowd that does not view him as an ally. This is a crowd that if he ventures out into it, there could be problems. Now, once the police pass by and the protesters are pushed down south of 60th, I believe the evidence will show that the car source that the defendant is stationed at is no longer in danger. There's no one there who's attempting to damage the property. There's no one there who's going to do anything to harm anyone there. The situation has moved on. Does the defendant stay there? Does he decide that he's done what he set out to do and it's time to go home? No. The evidence will show that the defendant, another individual in the group by the name of Ryan Balch, who you will hear from, decide to venture out into the crowd. They cross the police line at 60th and Sheridan, and they walk amongst this group of hostile protesters. At some point, they both wind up at a gas station on the southeast corner of 60th and Sheridan called Ultimate Gas. And you'll see some video of the scene there. It is a scene, again, of groups of people that are clashing with one another verbally. There's some shoving going on. And in the midst of this is Joseph Rosenbaum. And you will hear some testimony about Mr. Rosenbaum and his activities that night. Mr. Rosenbaum had been discharged from the hospital that very day and had come back to his home of Kenosha, had met up with his girlfriend, Carrie Ann Swart. He couldn't stay with her, so he left her and came downtown and got caught up in the midst of these protests. You will see him on videos. You will see photographs of him as he's walking around. He is carrying a plastic bag. Part of that plastic bag is clear and see-through. It has a string, white string, drawstring to it. It is the type of bag, I believe the evidence will show, that you get at the hospital when you're asked to put all of your personal possessions in a bag. Your shoes, your watch, your phone, your jewelry, etc. That's the type of bag it is. And I believe the evidence will show that he was carrying it around most of that evening. And at various points, the evidence will show that Mr. Rosenbaum is agitating. He is getting in people's faces. He is using obscenities. He is essentially daring people to respond. In fact, at ultimate gas, I believe the evidence will show that he actually gets right up in the face of armed people who are similarly armed as the defendant, who have similar AR-15 type rifles on. And he is literally confronting them in their faces. None of those folks shoot him. They push him away. He's 5'3", by the way, 150 pounds. They push him away. No one appears to take him as a serious danger. The defendant is at the ultimate gas station during part of this, so is Ryan Balch. I believe Mr. Balch will testify that there was an understanding that when we cross south of 60th, we stay together. We try not to intervene in anything. But if we get separated, head back to 59th Street, where our original group is. Mr. Balch does. The defendant attempts to. He comes up to the police line. They won't let him pass. He says, "I work at that business," and points to 59th Street. And again, they won't let him directly through the line. Now, I believe the evidence will show that he could have easily gone a block in either direction if he really wanted to go back, but he turns away from the police line, returns to the ultimate gas station. And a few minutes later, we see him on the video of a man by the name of Corey Elijah, who will testify very shortly here in this trial. Mr. Corey Elijah was one of these people out on the streets who was Facebook live streaming the events of that night. And he catches the defendant passing right in front of him with a fire extinguisher. The gun still slung around his body, strapped to his body. And Corey Elijah will testify, this caught his attention. Where's he going with this fire extinguisher? And so Corey Elijah decides to follow with his video, recording the entire way. And we will show you that video. You will see that as Corey Elijah leaves the ultimate gas station at 60th and Sheridan and heads south, he passes by the defendant, who by this point is walking, holding a fire extinguisher in his hand, all by himself. Corey Elijah, I don't think, registers that that's the person I originally saw, and he keeps on passing him, and as he continues, he passes by Joseph Rosenbaum, who at this point has taken his shirt off. He's got shorts on, and he's taken his shirt and kind of wrapped it around his head. And Mr. Rosenbaum is still carrying that plastic hospital bag and walking down Sheridan towards the 63rd Street car source. The defendant is behind him at some distance. As they get down to the 6200 into the 6300 block of Sheridan Road, that block on the west side of Sheridan has a house right at the corner of 62nd and Sheridan. And then on the south end of that block, the south half, is the car source lot. You will hear testimony from someone from the FBI who was up in a plane that night taking video. And we will show you the video. It is an infrared video, which means it picks up heat. This is at nighttime, so regular cameras, especially from an airplane, aren't going to be able to see everything. So the infrared helps us to see in the dark. The video picks up Mr. Rosenbaum. It is quite clear to see him because he is a white blob. Infrared picks up heat. He doesn't have his shirt on. So the cloth of a shirt would help conceal some of that heat, but when you don't have your shirt on, that heat radiates, and the infrared picks it up more clearly. So he's very easy to see in the video as a white dot. You see him running towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant. As they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said. But what's clear is whatever that confrontation that was initiated by the defendant started, it caused Mr. Rosenbaum to come around the cars and start running after the defendant. The defendant drops the fire extinguisher right there and runs, carrying his AR-15. At some point during that foot pursuit, the defendant turns around, points the gun at Mr. Rosenbaum, who puts his hands up in the air. Now remember, he has got no shirt on. He's got his hands up in the air, almost like, what are you going to do? The defendant stops, pointing at Mr. Rosenbaum, continues to run. And right around this time, there is a gunshot from someone else. who we have identified by the name of Joshua Zeminski. This is an individual who's walking on the sidewalk, probably 30 feet away from where the defendant and Mr. Rosenbaum are running. Mr. Zeminski, for reasons only he can explain, decided to take his handgun and fire it one time in the air. As I said, this is in a different direction and many feet away from where the defendant was. Mr. Rosenbaum continues to pursue the defendant, and we will have Detective Martin Howard testify that he's timed the gap between Mr. Zeminski's shot and the eventual gunshots is about 2.5 or 2.6 seconds. Mr. Rosenbaum closes on the defendant. The defendant turns and fires 4 shots at Mr. Rosenbaum. You will hear the testimony from the Milwaukee County Medical Examiner, Dr. Douglas Kelly, that Mr. Rosenbaum suffered 5 wounds total from 4 bullets. Dr. Kelly will testify that the first 2 wounds that were inflicted upon Mr. Rosenbaum were to his lower extremities. We're not sure which order they were in, but one was to his right pelvis, fracturing his pelvis, and one was to his left lower thigh. Dr. Kelly will testify that these wounds caused Mr. Rosenbaum to start falling face forward. And you will see video of his body where it is found. He lands on his face down on the ground. As he is falling, the defendant fires 2 more shots. One of them hits the defendant in the back, Mr. Rosenbaum in the back. And that is the shot that kills Mr. Rosenbaum, according to Dr. Kelly. You will hear testimony from someone by the name of Richie McGinnis. Richie McGinnis is a reporter who came to Kenosha to cover the events of that night. And at some point shortly before these shootings, he encounters the defendant at 59th Street and interviews him. He talks to the defendant and then follows the defendant down Sheridan Road and is right behind the defendant as these shootings are occurring. In fact, he is in the car source lot. He is behind Mr. Rosenbaum when Mr. Rosenbaum is shot. And Mr. McGinnis will testify that one of those rounds came close to him, which is the basis for the count that we've alleged that Mr. McGinnis was recklessly harmed or placed in danger by the defendant. Mr. McGinnis will testify that when he saw Joseph Rosenbaum shot and fall to the ground, he immediately ran up and attempted to treat Mr. Rosenbaum. He took off his shirt. He used it to try and stem some bleeding. He rolled Mr. Rosenbaum over onto his back, and he's attempting to administer first aid. Many other people respond at that very moment to that location and attempt to help Mr. Rosenbaum. They eventually lift him up. They carry him across the street to Frederick South, formerly known as Kenosha Memorial Hospital, KMH, which happens to be right across the street. These folks load him into a hospital SUV that's there in the back of it, and it races off towards the emergency room to try and save Mr. Rosenbaum's life. That's what Mr. McGinnis does. The defendant, after shooting Mr. Rosenbaum, gets on his phone, calls Dominic Black and says, "I just shot somebody," and starts running away. Now, one of the things that you will see and hear in this case is that the defendant throughout this entire evening held himself out as an EMT, as a medic, that he's carrying a medical bag with him, strapped to his body. And yet, in this time of Mr. Rosenbaum there on the ground, injured, potentially dying, the defendant offers no aid, but instead runs. He runs up Sheridan Road. He encounters another member of their group from 59th Street, who you will hear testify, by the name of Jason Lakowski. Jason Lakowski is similarly armed. He's a former Marine. He had been with the defendant at 59th Street and had come down in response to the gunshots. Mr. Lakowski will testify that he met Mr. Rittenhouse as the defendant was fleeing the scene. And Mr. Rittenhouse said to him, "I didn't shoot anybody, but I need help." And Mr. Lakowski says, "Head up towards the police." So the defendant starts running north on Sheridan. The crowd starts yelling, "That guy, the defendant, just shot somebody," because that's all the knowledge they have at that point. And it's true. So they begin to chase after him. They clearly believe he's an active shooter, and they try and stop him. And I've already described to you the events that follow. Mr. Huber, the unknown individual, and Mr. Grosskreutz. So, when we talk in this trial about the nights of August 25th, we need to keep in mind the context of that night. We need to keep in mind the fact that there were hundreds of people on the street that night, experiencing the same chaos, the same loud noises, the same gunfire, the same arson, the same tear gas, the same hostile confrontations with people who believe the opposite of them. And yet, out of these hundreds of people, only one person killed anyone that night. Only one person shot anyone that night. When we consider the reasonableness of the defendant's actions, I ask you to keep that in mind. Now, in this trial, you are going to hear from a number of witnesses from the state. I've already told you about a few of them. We are going to begin the testimony with Dominic Black, and he will tell you a little bit about the acquisition of those guns. You will hear from Corey Elijah, who was live streaming the events that night. You will hear from Detective Martin Howard, who worked diligently to gather evidence, including many different videos, many different photos of the scene that night. We are going to use that television to show you these things so that you can see them yourself. I know many of you alluded to the fact yesterday that you've watched or read things about this. You will get the full story here in the courtroom, and you will see some things that have not been made public yet. We intend to do that by moving the TV as central as we can so that you can see it as up close and as well as possible. And we will show you as much as we can about the events of that night. You will hear from the FBI individual who was in the plane taking that infrared video that shows the defendant chasing Mr. Rosenbaum and initiating that confrontation. You will hear from other individuals who took video that night. You will hear more about Joseph Rosenbaum from his girlfriend, Carrie Ann Swart. She will tell you about his hospital stay. She will tell you about that bag. She will tell you about what was in that bag. You will hear about Anthony Huber. You will hear that he was a skateboarder, that he lived for skateboarding, that he was at the skate park at Penoyer Park all the time, that he actually knew Jacob Blake personally, that he came out that night because he wanted to show support for his friend, Jacob Blake. You will hear what sort of person Anthony Huber was. You will hear from other witnesses who've been affected by that night. You will hear from law enforcement witnesses who did a lot of investigative work to assemble all of the evidence against the defendant in this case. And you will hear from Dr. Douglas Kelly, who will testify regarding the cause of death of Anthony Huber, the gunshot wound to the chest. And you will hear that the shot that killed Joseph Rosenbaum was a shot to the back. And based on all of that evidence, I think you will agree with me that the defendant is guilty of all of these charges. Thank you.
Thank you, Mr. Bingham. Let's take about a 10-minute break. Please don't talk about the case during the break.
How is everybody doing? Well, now that I've had a little while to wake up and do things, can everybody hear me? How do you think this is going so far? Good morning, y'all. Got my tea. Don't forget to be awesome, by the way. Okay? Unlike some of the people in the chat. Just take it down a notch. Denise, take it down a notch. There was a guy earlier who was saying that he should be hung. You know what? Just take it down a notch. It's day one. We're in opening statements. You know, we like to keep our chat open, and we like to keep it so that people can have the conversation. But dang, just take it down a notch. It's day one. We're glad that people like you are not on the jury, you know. This is what a trial is for, so that we can hear the evidence and we can make an informed decision about whether the defendant is guilty or not guilty. That's the point of a trial. Outside of that, it just doesn't make sense to be arguing ridiculous things. And furthermore, if you're arguing about it, you must not be listening to it. So you're just totally closed off to the whole situation. So take it down a notch so that I don't have to get rid of you, because we don't want to do that. We're anti-censorship. We want to hear what you have to say, but, I mean, I got lots of kids, and I don't have any patience for obnoxious behavior. And I also don't like to babysit adults. So there's that. Okay. So anyways, that's my spiel. Good morning to you all. Good morning, Mama Bear, Sherry, Valerie, Witchy, Linda, Julie, Angela, Lady Katie. Hey guys, just kind of going through a few of these here. Becky, good morning, Minnie. Good morning, all. Casey, I know it's not, I'm not about censorship either, but it's like when you get obnoxious, just, I mean, it's just stupid. Shouldn't have to babysit grown adults. Oh, I'm hard to hear. Okay, hold on. Let me get myself up a little bit better. Is that better? Good morning, Patriot Lady. Billy Bob, is that better? Crystal, Diane, good morning. Good morning. So what are your thoughts on this so far? You know, I always am very impressed by the different things. Like when before they even started, they were kind of debating back and forth about the age and what the law has to say about the age. You know, so I'm a stay-at-home mom. I've got some college education, not a whole lot. I've got common sense, and so, but I'm not a Jill of all trades. You know, I can do several things pretty well, but when I need something outside my scope of expertise, my mom MacGyver-ness, I try to find a professional in that area, and I kind of depend on their expertise in that area, right? And so, for instance, when it comes to a lawyer, when I go and ask them questions, I expect them to know the answers, them to be able to provide me with information that I don't have. I could go and look it up. I could go and read about it. I could go and research it. But if I'm going to pay a lawyer to do said work, I'm depending on their expertise, right? And we had a situation here in our local area where a group of people were filing against the mandates and such, and they raised all this money, and then all of a sudden, somehow, the lawyer didn't know that an entire executive branch couldn't even be part of the lawsuit. And so it was this big ordeal that happened, and they got dropped out of it, and all this money. It was just like, we depend on people to be the experts, right? And I'm really impressed by the lawyers in here. They're sitting here arguing, about regarding the age, and what did they call it? Something self-defense. Oh, darn. I was supposed to be writing these things down, but I was waking up. Anyways, it was really interesting. And the opening statements. Oh, and it's really hard to not like this judge. My mom always says a day without laughter is a day wasted. And he makes me smile when he makes these little jokes, when he's like, he said when he sees the people on TV, it ruins the show for him because they're not doing it right. They're not opening arguments, they're opening statements. Oh, I love him. I love the judge so far. I think that he's super, super neat and down to earth. Okay. Yeah, that tea is hot. Oh, I'm sorry. Can you see it steaming? I have it sitting right in front of the camera. It is very hot. I had it. It was on a rolling boil. I was trying to run in here when I heard him say they were taking a break. Okay. Let's see. Hospital stay. Let's see. Sending a big hello to everyone. Oh, you got your shirt, Minnie. Awesome. I'm so glad that you got that. Let your faith be stronger than your fear. Yes, 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 yes. I'm trying to get some more going on with some awesome, strong biblical statements. I'm so glad to hear that. Let's see. Judge Wapner. Oh my gosh, my mom used to watch Judge Wapner all the time. I hated it. I absolutely hated it growing up. Every single day she watched Judge Wapner. Let's see here. Judge is actually funny. Yes, he is funny. I can like totally, let's see. I respect my mom's love for Judge Wapner now, but as a kid growing up, I was like, no more Judge Wapner. Oh, this is definitely hot. You can see it steaming. This is my it's mother's milk tea. So thank you very much, Billy Bob, and good morning. Okay, I won't badmouth Judge Wapner. It wasn't Judge Wapner. It was just being a kid. My mom was like, news, all news and judge shows. News and Judge Wapner. Judge Judy would throw the book at him. Too funny. Yeah. Hold on. Let's see. I may have bitten off a big old bite. Okay, so I typically go to the gym at night now, and having to get up at 7 is early for me. So, let's see. Matthew 10:16-31. What were we posting that for? What's the context in which you post that scripture? All right. You tried to frost your own hair. Yeah. Oh, Phil Donahue was great too. Okay, so there was a couple of things I wanted to talk about. I didn't take notes, which I will do on this next session. But the opening statements, it's it's interesting because there were a few things I didn't know, which is always, so I come into these things, I'm not on the jury, so I have the kind of the liberty to do this, which I've already made in my mind that Kyle Rittenhouse is not guilty. I did read on the charges, and I thought that if I would see him as guilty on anything, it would have been obviously the underage possession of a firearm and breaking curfew. But I don't even know if I would do the breaking curfew thing because I mean this is why I have the liberty to do this because I don't believe in curfew. So there's that. I could not be a jury person because I don't even believe in curfew. Like, I will go outside when I want to go outside. The government's not going to tell me when I can and can't do that, right? So, very funny, dear. Yeah, I've been going to the gym at night and staying up super, super late. Because it's the only time. I'm a swing shift type person, so I do my best work. I'm most productive and stuff between 3 and 11. Like, that's my time of day. So, I mean, I will yawn at the gym in the morning, in the afternoon. We just went on Sunday afternoon, and I'm in the gym yawning. Yawning, folks. Yawning. Because I'm not good before 3 o'clock. I just am kind of like worthless. But anyway, so I would, if I was going to find him guilty on any charges, it would have been those two. However, since I don't believe in curfew, I likely wouldn't have found him guilty on that. But then the opening statement started, and there was a few things that I didn't know that he was saying, and it made me pause. It made me pause. And I think that is the point of a trial. Like, and it's the good part. It's one of the good parts of our system. I think our system is definitely broken in many ways. Our justice system is broken in many ways. But I think the bones of it are good. The bones are good. And so that's the beauty of the trial. I mean, we're on day one, just heard the opening statements from one side, and I took a pause and I was like, oh, hold on, I didn't know that, And so, I'm looking forward to this. I'm really looking forward to this. I think this will be a lot of fun to do this all together. Oh, that's good stuff. We don't want any injustice to come to Kyle Rittenhouse, though. And the thing about it is, I've experienced the things that he was experiencing in that time period. And the lawyer kept saying, the only one who killed someone was the defendant. The only one. But I mean, he could have completed the context of that statement by saying the only one who killed somebody in Kenosha, Wisconsin during a riot over a criminal situation happening was Kyle Rittenhouse. Like, that would have been a more full contextual statement. There were riots all over the country where people were being killed by the rioters. And this took place for months on end, every single nightly, so, and unless we've said this, me and BCP have both said this many times, until you experience Antifa for yourself, and it's much different than just watching it. I mean, live streaming is definitely better than watching it on a news program, right? Like a mainstream news program. Live streaming is a step better than that, but a step better than that is experiencing it in person, because it's much different. Because I've watched it obviously a lot myself, and experienced it through watching it and BCP telling me about it. But even when I experienced it firsthand, it was much different. you know? And so when you're there and you are experiencing it, you know, having a fear is definitely normal. That's going to be normal. So, a kid fearing for his life is not an abnormal response to what was going on that night. And so, I'm definitely looking forward to seeing how this all plays out. When your kids are teenagers, you'll believe in curfew. Oh yeah, well, yeah, I guess that is definitely true. I mean, for like, well, I guess Kyle Rittenhouse isn't. He is an adult. I was speaking more for adults, but I guess when it comes to that makes sense. Becky, you're right. Teenagers are a whole new ball game that I wasn't fully prepared for. I wasn't ready. I was not ready. And it almost just comes up on you. Like, you know, they're preteen and then they kind of turn teenager, but it almost happens like overnight. Like all of a sudden, boom, there it is. It doesn't really happen gradually, in my opinion. It just all of a sudden is there, and it threw me off. Okay. Use your time available. Yep, I use my time available. Oh, thank you. Yes, it is my time. It is my downtime. You know, going to the gym at night has really been a blessing because it sometimes is hard to work around babies, you know. And I've been bearing children for a good decade now, so straight. So it has been nice to be able to have that time. But I definitely need to just come home and go to sleep instead of staying up till 3 o'clock in the morning. That's ridiculous. I don't know what I'm thinking. But then I'm all like hyped up, you know, so I don't know, whatever. Curious how they knew what shot was fired first. You know what? I was wondering that too when he said that. They must have watched a ton of video, live stream video. They had to have, right? Because the way that he was putting these things together was very interesting. The timeline that he had, you know, people running here and going there and what they were carrying and different things. He definitely had a very good timeline that he put together there. Sunshine, the thing that made me pause was when he said that Rosenbaum, is it that guy? Was that the one he talked about first? He shot him in the back. I didn't realize it was in the back. So I'm not sure why. I don't feel like it went into detail on that. So that made me pause because anybody who gets shot in the back, I have to wonder, I mean, were they coming towards you? I mean, or why, you know, why was it, if they weren't coming towards you or whatever happened, how did you end up shooting them in the back if they were retreating? Like, did he hit you and then run? I'm not really sure. But that made me pause. Yeah, we know how much death and destruction happened over the summer. We're not stupid. They can't gaslight us on that. We saw a lot. They firebombed police at night. Are police not people? Well, yeah, police are definitely people, but not according to them. Well, not according to a lot of people, but yes. You know, a lot of people would put police below property. They're like, human life is more valuable than property, but when it comes to police, all of a sudden, well, property is more valuable than police. And it's a lot different when you feel that fear for yourself. Exactly. So we can say that, well, the situation wasn't really, you shouldn't really have been that fearful. But for each individual, it's going to be different. For instance, when we were attacked on August 7th by Antifa, I had my kids there. And I made a statement at one time. I was like, you know, because the next day was the worship session that we were having. And I said, I'm probably not going to feel the same today because I don't have my kids with me. And sure enough, I get there and I didn't have that same weight. I didn't have that same burden on me that I had the day before when my kids were with me. So it's, you know, every person is different. Every day, minute, hour is different. Every situation is different. You just don't know when that fear is going to come up on you, and you may fear for your life or not. The next day, I was all over the place, you know, talking to Antifa and doing this. I had zero fear whatsoever because I just didn't have that same burden. I knew my kids were at home and they were safe, and it just was a very different state of mind and situation. So, yeah, you just never know when the fear is going to take you over. Somebody said boys were supposed to be easier to raise. Yeah, they are supposed to be easier to raise, but you know what one of them just did yesterday? He came into the room and passed gas in his sister's face. Like, is this what I'm going to be dealing with? Oh, it was ridiculous. I couldn't believe. I can't imagine how afraid for his life he had to be with those people running after him screaming. That's a whole different game changer for me. Yeah, you know, I feel like because, again, and I'll just keep referring back to August 7th because there was a moment in time where we were all standing around and there was one guy directly in the middle and he was like fumbling, trying to get something out of his backpack, and we were all kind of watching like in anticipation, what is he going to pull out of his backpack? I can't imagine if it's, and then the next night, after the worship service, now that was during the day, the first night. The next night after the worship service, it was at night, and you can't see as well, and they were lighting off bombs and throwing things, the flashbangs. You don't know where it's going to land. What if it lands right next to you? What if what they throw this time is even more dangerous? You never know what will happen. And it brought on a whole different set of emotions with that, even with from the morning to the night. So, I mean, to be out there, and he, you know, he didn't go there by himself, but in that moment, he was by himself with these people. So that's scary, you know, and he's 17 years old. I mean, he is a child. He's a baby. He looks like a baby. He is a baby. He's a baby. Like, I have a 18, 17, 16-year-old. They're babies to me. Like, they are babies. They're not grown adults who've lived life. Okay, we're coming back in.
Before we proceed to the defense opening, it's my understanding that counsel is going to be showing videos to the jury.
Okay.
These aren't evidence yet. I don't know what's going to be shown, and I think it's unusual procedure. I've often considered using exhibits in my opening statement, and I think it's generally accepted that they're not evidence yet. So we can't be showing them to the jury unless they're in evidence, and we don't have any of this in evidence yet. So I would object to that.
Well, he does need to tell you what he intends to show. No, I got to turn things on here. He does need to tell you what he proposes to show, and me too. But the rule does not preclude their use during opening statement at all. What's up, Mr.
Your Honor, the first slide is a jury instruction, part of self-defense. The second slide is a picture of Joseph Rosenbaum wearing the maroon shirt for identification purposes. The third is a video at the Ultimate Gas of Mr. Rosenbaum having to be restrained. The fourth is a still photograph of Mr. Rosenbaum walking down the street after arming himself with the chain. The fifth is a picture of Joseph Rosenbaum taken from the video at the Ultimate Gas Station of him and Mr. Zeminski. The sixth photograph is once again a picture taken by Nathan DeBrune of Joshua Zeminski and Joseph Rosenbaum starting a fire at the trailer. And in that one, Mr. Rosenbaum is wearing a blue mask. Number 7 is a picture from the Ultimate Gas Station taken from a video of somebody who's commonly been referred to in this as Yellow Pants Man. Kelly and Joshua Zeminski, showing Joshua Zeminski armed with the weapon that was the first weapon fired at car source number 3. Number 8 is a picture for identification of Richie McGinnis. Number 8 is a picture of how Richie McGinnis was dressed that evening so he can be identified in the videos. Number 9 is Gage Groskwitz and his backpack, taken from a video that has been agreed to be introduced into evidence. Number 10 is a still photograph of Gage Groskwitz running down Sheridan Road towards my client, arming himself. You can see him pulling the gun out of his back waistband. Number 11 is a still photograph of Anthony Huber holding his skateboard. And then number 12 is a picture of Anthony Huber holding his skateboard, so you can see the whole skateboard, but dressed the same way as it is in number 11. Number 13 is Anthony Huber holding Mr. Rosenbaum back at the confrontation at Ultimate. Number 14 is the photograph of Jump Kick Man, the non-complaining witness, kicking my client in the head. 15 are 2 close-up photographs taken from that of the shoes of Jump Kick Man. 16 is a photograph of 11:40 p.m. when Kyle Rittenhouse is going out with Mr. Balch, and he's confronted by Yellow Pants Man and 3 other armed individuals that evening. And those photographs are blown up in 17, showing one individual with a noose, the other individual with rocks in each hand, and the other one a picture of the individual in the blue shirt armed. 18 is a video where Mr. Rittenhouse tried to return to the 59th Street car source and was stopped by law enforcement and the Bearcats. Number 19 is a still photograph taken from Mr. Rittenhouse at Ultimate as he's leaving with the fire extinguisher, his medical pack, and his gun, heading towards car source 3. 20 is the video, what's called the infrared video, with Kelly Zeminski, Joshua Zeminski, Rosenbaum, my client, and Richie McGinnis circled and identified. 11:48 is a still photograph of Mr. Zeminski's arm in the air, firing the first weapon, the first shot. 22 is that same photograph from the video, same video, a photo just a couple of seconds later with 2 circles, one identifying Mr. Rosenbaum in yellow and another one showing Mr. Zeminski with his arm raised firing. 23 is a video taken from, and I always forget this gentleman's name, Lucas Zanin, from 63rd Street, right west of Sheridan, which forms the south edge of car source, and that's what Kyle was running to. There's approximately 100 people there bashing all the car windows, in there with pipes, bats, things like that, jumping on the cars. And you hear the first shot, which is Zeminski's, and people kind of stop a little bit. And then you see Kyle, you hear the next shot, and all of those people start taking off from car source. 24 is the video where Kyle begins leaving car source 3 after the shooting. And on that video, you hear somebody who has been identified as Kelly Zeminski yelling, "Get him, kill him," things like that. He just shot him. 25 is Gage Groskwitz's video where he runs up to Kyle. It's about 7 seconds. Runs up to him as he's running down Sheridan. At that point, Mr. Groskwitz is unarmed. He asked Kyle what he did. Kyle said, "I'm going to turn myself into the police. I had to." Photograph 26 is for BG on the screen. Photograph of an unidentified individual in a white sleeveless, or what's commonly referred to as a wife beater shirt, hitting Mr. Rittenhouse in the head, knocking his cap off. And then right after that, you see the next photograph from that video of circled Mr. Huber picking up after a skateboard, which he had used to strike my client in the head. The next photograph is a still photograph of an individual running up to Kyle as he's on the ground. There are several individuals in that photograph. One of those individuals being Jump Kick Man approaching from Kyle's right. And the next photograph is him kicking Kyle in the head. 30 is the picture of the close-up of that and the shoes. 31 is a photograph of Mr. Huber striking Kyle Rittenhouse in the head with his skateboard, held by the trucks in his right hand.
Held what?
The trucks of the skateboard.
You know, did I look like I skateboard?
They're called trucks.
Okay, wheels. To me,
Okay.
they're wheels.
Fine. The wheels with his right hand while he's grabbing Kyle's gun, his bare hand, touching Kyle's gun with his left hand. The next photograph is depicting Jump Kick Man getting up from the ground, Mr. Huber with his hand once again on the gun going forward and still having his skateboard. 33 is a close-up of that photo. 34 is, you can see the strap on Mr. Rittenhouse's gun being pulled taut. Mr. Groskwitz running into the frame from the right of the frame. Next is Gage Groskwitz standing in front of Kyle Rittenhouse with his hands up. Kyle does not shoot. Next, Gage Groskwitz lunges forward with his right hand pointing directly, and that is when the shot is fired. And then there's a picture of Kyle Rittenhouse on the ground, individuals approaching him, one with a pipe, one with his hands up. He backs them off, does not fire. 11:51, him video trying to turn himself into the Kenosha Police Department and turned away. And the final is a photograph from the Antioch Police Department surveillance cam at 1:20 a.m. of Mr. Rittenhouse and his mother turning himself into the Antioch Police Department.
You know, I guess we don't need any witnesses. Well, we've got the whole trial there. I thought the opening statement was supposed to be a summary of the evidence, not the evidence itself. This is, I think we're up to 41 videos and photos that are going to be seemingly introduced through the testimony of Attorney Mark Richards. This is a highly unusual procedure, Judge. Both sides will have the opportunity to call witnesses to talk about these things. We will have an opportunity in closing arguments to characterize these things. But to give the jury what the defense considers, and I'm not conceding that these things are all the evidence or even that a lot of these things are relevant, but for the opening statement to essentially be the entire defense case and all the evidence, showing it to them is highly unusual. I took the approach in my opening statement, and I guess I was not pushing the envelope as far as I should have, but it's always been my approach that I will describe what I believe the evidence is going to be, but I'm not the witness. I'm not giving them the evidence. That's what the testimony's for. We've had a stipulation as to the authenticity of a lot of the things that counsel's talked about. That does not mean that they're admissible into evidence. It does not mean we're conceding relevance to those things, and I anticipate that there will be some arguments as to the relevance of a lot of these things. We've already had some arguments about some of these things. So you stressed that it took 5 minutes for him to list all of those things, let alone what it's going to take to actually show them and play them for the jury. So I think as a general policy, Your Honor, and I understand it's not necessarily the law, but witnesses should be presenting evidence, not the attorneys in their opening statement. So I object to this procedure. I think it's overly long. It's duplicative of what the evidence is going to be. There'll be an opportunity through witnesses to present all of that. I think counsel should be describing what he thinks the evidence is going to show. That's appropriate. But showing them all the evidence this way, why do we even need witnesses at this point? I'll get up and I'll play all the videos I want to play. They'll play all the videos they want to play, and then we'll just be done without any testimony. That's not the way this trial should work. So I don't think this is a proper procedure, Your Honor, and I do object to it.
Okay. Well, first of all, are you going to be able to authenticate each and every one of these?
All of these come from exhibits that have been agreed or stipulated to their authenticity.
And they're all going to be relevant?
They all are relevant. They've all been...
It sounded like what I've already heard about, by and large. The standard is not what you did or what you can do or could do. The standard is what the law allows, and I can remember studying this 50 years ago, that this was an acceptable way, with judicial permission, to make an opening statement. We see it more in civil cases than in criminal. It's not customary in criminal cases, but I've seen it done by your office. And I have to say that you're right. This is a record number in terms of the numbers. But on the other hand, there's a large number of crimes being charged and separate acts that are being asserted with respect to both the acts that the state alleges were unlawful and the defendant's claim of self-defense. So given that they do appear all to be relevant and they've been agreed as authentic, then I don't see any reason that I should interfere with his right to make an opening statement. Mr. Binger makes a good point in reinforcing my comment that this is supposed to be brief and informative. So keep it.
I don't think I'll be any longer than him, Your Honor.
Bless you. All right. Anything else?
Yes, Your Honor. One of the motions in limine I filed, which was not objected to by the defense, is that there be no reference to any pending or prior criminal cases or convictions with regard to Joseph Rosenbaum. The parties are aware, the jury is not, that there was at the time of his death a pending criminal case between Joseph Rosenbaum and his girlfriend, Carrie Ann Swart, and there was a bond condition that prohibited Mr. Rosenbaum from having contact with her. The purpose of my motion in limine, which, as I said earlier, was not objected to by the defense, was we're not going to talk about that. Now, I made a reference in my opening statement to the fact that Mr. Rosenbaum saw Ms. Swart that night and was basically was not allowed to stay with her, or was not able to stay with her that night, so he left her residence. And I purposely worded it that way, Your Honor, because there are many reasons why someone may not be able to stay at someone's residence. It could be because of a bond condition. It could be for a myriad of other reasons. It's my understanding from an off-the-record discussion with counsel that he intends to go into this. He believes I've opened the door to it. I wanted a pretrial ruling from the court on this issue. We got one. And I'm now raising it because if it's going to be mentioned in the opening statement, I think this is the time to address this issue rather than in the middle of an opening statement. So I'm bringing it back up again. I do not believe that my statement opened the door to it. And frankly, my statement is not evidence, so I don't know that it can really open the door anyway. But by and large, I was very careful in the way I worded that, and I don't think it opened the door. I don't think, regardless, this is a relevant issue for this trial. Mr. Rosenbaum's conduct with regard to Ms. Swart has nothing to do with what was going on the street that night. So it is completely irrelevant, and I would ask that the court reaffirm its prior ruling on my motion in limine.
Your Honor, he can't have it both ways. He can't go and say he was at the house and he couldn't stay there and not. Why can't we tell the jury why? Because there was a no contact order. It's not appropriate. He thinks he didn't open the door, but he danced through the door. And he also talked about the hospital, got out of the hospital. He was in a mental hospital. And he's going to put her on the witness stand and we're not going to get to ask that? That's insane.
I was very careful about the word hospital, Your Honor. I believe it was actually St. Luke's in Racine, which is a medical facility. It is not a mental institution. This wasn't Mendota or Winnebago or something along those lines. And frankly, I'm not even 100% certain why he chose to check himself in. But again, whether or not Mr. Rosenbaum needed a new kidney or needed medications for mental illness or was going in to have his blood pressure checked has nothing to do with the events of this night. And frankly, it's just a backdoor way of attacking his character and suggesting to this jury that somehow because there's going to be an allegation from the defense that he had some sort of mental illness that had something to do with his behavior that night. I'd love to hear an expert on that, I guess, if they want to try and present that, and we can go down that line and we can talk about whether mental illness contributed to his behavior. What was his diagnosis? What medications were he on? We could open that door and go all the way through it, but that's a mini trial on an irrelevant issue, and if it's going to come in, there's a way to get it in through an other acts motion, which was never filed by the defense, and I certainly have not opened the door when I talk about the word hospital. This could be COVID treatment. It could be a kidney transfer. It could be anything. It does not open the door. And again, I was very careful in the way I worded that, Your Honor. You know, if I start talking about his medications or I start talking about, you know, seeing a psychiatrist or something like that, that's different. Hospital is a very nebulous term that could mean a myriad of things.
You know, help me out here. I thought when I read the pre-trial motions, and I know there were a series of them on which there was agreement, so I probably may not have the best recall of those because I didn't have to put too much thought into it. But I thought that the references or the statements which were attributed to Mr. Rosenbaum were, "I just got out of jail today." You're telling me that there was also discussion about hospital? No? Or
there's
going
no
on?
video or statements or audio of Mr. Rosenbaum talking about the hospital. The only relevance it has, Your Honor.
Well, wait a minute. Let me. So.
Sure.
It was. Is there testimonial? Are we going to hear testimony that he made statements that he had just gotten out of jail that day?
There's going to be statements to that effect.
Okay.
My
But in fact, your statement on your opening statement was, and I will tell you this. I'm going to ask you to try to reconstruct it for me, or if necessary, I'll have the reporter read it. But I don't recall the exact statement. I do know that I thought at the time, I'm surprised he's going into this because it may trigger a response. So what exactly did you tell the jury?
What I said, Your Honor, is that Mr. Rosenbaum had gotten out of the hospital that day
Right.
and was carrying around a plastic bag,
Right.
which is the kind of bag that hospitals give you to carry around your personal
Okay.
belongings. The only relevance that has to this case
Well, I
is
don't know.
that's the
I just
bag.
wanted to get
Sure.
the statement.
Yeah, and I
Now,
was doing that because
okay.
the bag comes in, and
Okay.
that's the only
I understand.
relevance.
Okay, now, and you also made a statement about his being with the person by whom he was allegedly bound not to have contact.
That's true.
And do we know the exact scope of that order?
I believe it was a straight, typical,
Don't
no
tell me
contract.
typical. No.
We can look it up, Your Honor.
Yeah. Well,
It was
what
a
did you
bond
say about
condition.
it? What did you say about it?
What I said is that he had seen her after he got out of the hospital,
Right.
that he couldn't stay with her, and so then he left and essentially came downtown. And Ms. Swart will testify,
Why
and
did
she
you
will
say
talk.
that he couldn't stay with her?
I'm sorry?
Why did you say that he couldn't stay with her?
I said that because it explains why he left and came downtown. He's got a hospital bag, Your Honor. It's a little unusual, I think, for someone to be released from a hospital, have a bag of their personal belongings, go to their girlfriend's place, and then continue to walk around with it. That's a little unusual. We know what was really going on.
And by the way, how do we know that he had been there and had left? Is she going to testify?
Yes.
Okay.
Yeah, and so she's going to talk about seeing him. She's going to talk about that bag, and she's going to say she saw what was in that bag. And this comes into play, Your Honor, because this is the bag that was thrown at the defendant. There's been some allegations out there that this is a Molotov cocktail, or it's got chemicals in it, or it's got something that could cause the defendant harm. It had toothpaste,
Okay.
mouthwash, a water bottle in it. That's the narrow relevance of this bag.
Well,
That's why the
I'm not
hospital.
concerned, the relevance is not something I want to talk about now. I want to talk about what you said and
Sure.
why he thinks it is worthy of response.
He's misrepresenting the facts of the case to the jury by saying hospital, when it was a mental hospital. Mr. Binger knows full well
Why isn't that a hospital?
he had gotten out for a suicide attempt.
So,
And
it's a hospital.
And let the jury know what type of hospital it was. Why he was acting the way he was. He was not acting appropriately. That's part of the defense. And,
Boy,
and then he goes and says, can't stay there. Why can't he stay there? Because there's a court order that says he can't. He wasn't supposed to go there in the first part.
And if he was on trial for violating his bond, then we'd have that trial. But he hasn't been tried or convicted of that because he's deceased. But, Your Honor, and by the way, we have the bond condition here. It's no contact, including the residence, electronic or third party, with Carrie Ann Swart and the Park Ridge Inn, which she stays there, and they had been staying there together until that criminal case started. So, if we want to charge Mr. Rosenbaum with violating his bond, what good would it do? He's deceased. But yes, that is true. But again, it doesn't make him a criminal on this evening. It doesn't make his behavior help explain any of that stuff.
I don't think, as far as your opening statement, you need to respond to his statement about the hospital. I'll have to separately decide
Understood.
at a later point as to whether he had been hospitalized and for what. I don't know if that's admissible or not. I suspect that it is not, but I'll keep an open mind. As far as his not being there or not supposed to be there, again, I'm not sure that I want to hear about that in your opening statement. Again, I'll hear you later as to why you think that would be relevant.
Just because he's talking about my client traveling here from out of bounds,
Right.
and he's trying to say, oh, he had a good excuse for not being at home. He couldn't stay there that night. Well, the jury should know why he couldn't stay there.
Well, I don't know. If he can't stay there, he can't stay there. She could have kicked him out because she didn't like his having a hospital bag. I don't know. I'm not sure it's necessarily relevant. He was where he, like the defendant, was not supposed to be, allegedly, and we'll let it play out. But don't talk about those two things in your opening statement. Anything else?
No.
Okay.
Hello?
Would you come down, please?
Yes.
Okay. Good. Welcome back. What did I say? 10 minutes, right? Judicial time. When you're dealing with, what do we got? 5, 6 lawyers in the room? What do you expect? All right, let's go, Mr. Richards.
May it please the court, ladies and gentlemen of the jury, good morning still for the next 10 minutes. This is my opportunity to tell you and show you what I believe the evidence will show. You've heard the state's opening statement, and now I will give mine. We have two very different outlooks on the events of August 25th of 2020. Kyle Rittenhouse was present in Kenosha, Wisconsin on the evening of August 24th. He stayed at his friend's residence, Dominic Black. He saw on the live streams and things like that the events of the 24th. He saw Car Source number 1, as I refer to it, the one that's on the east side of Sheridan Road, burn, all of the automobiles burned, destroyed. He saw the looting going on. He saw the other businesses burnt down. And the next morning he went down to downtown Kenosha to look at the damage. He stopped and he helped clean up at the old Ruther High School. I think it's called something else now, but when I was around here it was called Ruther, and before that Bradford. And he saw that. He met one of the owners from Car Source and they talked, and they decided that they would offer their services, him and Dominic Black and Nick Smith, to help protect the property of Car Source. Ladies and gentlemen, the evidence will show, in spite of what the media and public statements and things like that have been, the evidence will show that Kyle Rittenhouse had strong ties to Kenosha. His father lived in Kenosha. His mother lived in Antioch, Illinois. Kyle worked here in Kenosha County at the Recplex in Pleasant Prairie as a lifeguard. He went downtown to clean up the graffiti. Him and Nick left there, and they decided to come back that evening and help Car Source Lot 2, which is at 59th and Sheridan, and initially Car Source 3 at 60th and Sheridan. And when they were doing that, they met other individuals who had come to town at the urging of websites and things like that, and then just a general, I would say, distaste for the destruction. And those guys from the West Bend area, Ryan Balch, Lakowski, Joanne Fiedler, agreed that they would all help protect the Car Source lots. And initially they went to the lot at 59th early in the evening. And what will end up being, you will see the events of that night unfold in video and still photographs. But ultimately, what this case will come down to, it isn't a whodunit, when did it happen, or anything like that. It is, was Kyle Rittenhouse's actions privileged under the law of self-defense? That is, that the defendant believed that there was an actual or imminent unlawful interference with his person. The defendant believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and that his belief was reasonable. You as jurors will end up looking at it from the standpoint of a 17-year-old under the circumstances as they existed on August 25th of 2020. And Mr. Binger makes a big thing out of Kyle Rittenhouse was the only person who shot somebody that evening. True. Mr. Rittenhouse was the only person who was chased by Joseph Rosenbaum that evening. This is Joseph Rosenbaum. And what's important in this photograph is, one, it will allow you to identify him throughout the course of trial. Notice the belt, the baggy, lengthy jeans, and there will be a fair amount of testimony, I'm sure, regarding the maroon shirt. He's obviously currently wearing it. Mr. Rosenbaum was at a location, and Mr. Rosenbaum had, along with other individuals, started a dumpster on fire. And when somebody put that dumpster that was very close to a gas station out, Mr. Rosenbaum became enraged. I'm going to go back. Is the sound on?
Shoot me, nigga! Shoot me, nigga!
That's just a brief snippet of that interaction. And he was upset, and he's yelling that he wants to be shot. And you'll see individuals in the full video, which you'll see in the course of trial, holding him back, trying to stop him from getting at an individual who is dressed with a baseball cap, an AR rifle, and long pants. Excuse me, short pants, who looks very much like Kyle Rittenhouse. Here's Mr. Rosenbaum during the evening. Him and his friend or associate, Joshua Zeminski, had just come from starting a trailer on fire. He arms himself with a chain and goes up and down Sheridan Road, carrying this rather heavy chain used to tie down equipment. Next is a still photograph taken from the Ultimate gas station where he was shouting, "Shoot me, nigger, shoot me, nigger," at a Black Lives rally. Who is that behind him? Joshua Zeminski. The evidence will show that Mr. Zeminski, also named as Alec Blaine, and Mr. Rosenbaum are together throughout the evening. And Joshua Zeminski plays a central role in this scenario on August 25th. One, creating chaos and havoc with Mr. Rosenbaum, and two, more importantly, when we finally get to car source number 3, Mr. Zeminski is the individual who fires the first shot that evening, behind Kyle Rittenhouse as he's being chased by Mr. Rosenbaum. Here's a picture with 2 circles. Mr. Rosenbaum and Mr. Zeminski starting the trailer on fire on Sheridan Road along with a dumpster. You see the photograph, the second one circled. Testimony will show that that is in fact Mr. Rosenbaum wearing a blue mask, not his shirt over his head, and carrying a bag, which I'm sure there will be much testimony about. Other individuals in this, once again, Mr. Zeminski. In the photograph taken at the Ultimate, this is a still from one of the videos you'll get to see, is Mr. Zeminski armed with the weapon that he ultimately fires at the car source 3. The individual with the red hair is Kelly Zeminski. She has a backpack and there's a circle on her hand with a big, heavy flashlight. As you can see, there was no need that evening for a flashlight other than it being a weapon. Count 2 is an individual by the name of Richard McGinnis. He was a reporter covering the riots in Kenosha. He had covered the riots in Portland, Minneapolis, and he will tell you, when he's called to the witness stand by either the state or myself, that he was dressed like this that night. The black t-shirt with the white back, the helmet on his head, and he had interviewed Kyle Rittenhouse and talked to him, and Mr. Balch and Rittenhouse were going to go out and see if anybody needed medical attention that evening, and Richie McGinnis was going to follow along. He will testify that he goes out with them, and eventually they have an interaction with the individual who we refer to as Yellow Pants Man. This is Gage Groskowitz, the individual who is the victim, or excuse me, the complaining witness in count 5. I apologize. And in that photograph, you see that he's wearing a backpack and he has his cell phone in his hand, as he does throughout the evening, filming. Photograph 10, excuse me, the next photograph, is, the evidence will show Gage Groskowitz running down Sheridan Road, and you see his hand going into the back of his waistband, pulling out a firearm to arm himself. The evidence will show, through testimony of an individual by the name of Nathan DeBruin, that yellow dot right up there is where Kyle Rittenhouse is as they chase him down Sheridan Road. Mr. Groskowitz is not in any danger. Kyle Rittenhouse has already told him that he's going to turn himself into the police, yet he arms and continues with the mob to attack. This is a picture of Anthony Huber, the individual who attacks my client as he's laying on the ground after being kicked in the head by Jump Kick Man with his skateboard. He hit him with the skateboard as he was running down Sheridan Road, and then as he's laying prone on the ground, he comes in for another hit on his head, and then grabs Kyle Rittenhouse's firearm to try and take it away from him. The next photograph is a picture to look at the whole skateboard, the size of that skateboard, the trucks of that skateboard. Ladies and gentlemen, I would love to be able to hold up that skateboard in front of you as evidence today, because then you could see it. You could see the weight and the heft of what a skateboard is. And what that skateboard would do is somebody takes it in their hand and swings down on somebody's shoulder, head, and neck, trying to separate the head from the body, as Mr. Huber did. But
Your Honor, I'm going to object to the argument here, Your Honor. This is straying beyond a characterization of the evidence, and it's Mr. Richards' interpretation as an argument.
you'll see the photographs, you'll see the videos, and ultimately you'll get to make the decision of what Anthony Huber was trying to do. The skateboard doesn't exist because Ms. Giddings, his girlfriend, in spite of repeated requests by Detective Howard, refused to produce it. That's what the evidence will show. Mr. Huber, at the ultimate gas, holding back Mr. Rosenbaum, who is ultimately the individual who lit the fuse that night. Man I refer to as Jump Kick Man, or the non-complaining witness. Kyle is laying on the ground after being knocked to the ground by an individual hitting him in the head with a rock, Anthony Huber hitting him with the skateboard, and Jump Kick Man comes in, kicks him square in the face with his black boot. Close-ups of that. And as he's kicking him in the face, Kyle fires 2 shots at that individual. He's not hit. He gets up and he runs away into the night, never to be seen again, never coming forward to identify himself as a victim, complaining witness or otherwise, to law enforcement. We looked for him, the evidence will show. The state looked for him, the evidence will show. Those are the big players in this case. But ultimately, what you'll end up having to decide, looking at all the circumstances of that evening, are the events that occurred over really a brief 15-minute period, but more importantly, 3 minutes. The police spread or push people south to approximately 60th. That's something we can agree. There's no line set up to stop Kyle or anybody else going in a southerly direction down Sheridan Road. There's no statement that if you go in that direction, you can't come back if you have business in that direction. Kyle, an individual by the name of Ryan Balch, followed by Richard McGinnis, go down there, Sheridan Road. And at 11:40, they have a conversation yelling medic. And you'll see the videotape of this event. Kyle's got his medical bag, his gun, and he comes upon these three individuals. And the individual in the yellow pants accuses Kyle Rittenhouse of pointing a laser sight from a gun at him. Kyle shrugs it off, does not want confrontation with these individuals, does not point his firearm at them, and he leaves. Why does he leave? Because he doesn't want trouble. These are the three individuals who are with yellow pants. One individual is carrying a noose. I don't know what that's for. The other individual, the testimony will be from Kyle Rittenhouse and Richie McGinnis, had rocks in his hands. And then the blue-shirted individual was carrying a 9mm firearm. Richard McGinnis will tell you about the marauding nature of these individuals. He was so intimidated by them after Kyle walked away that he had to give up 2 White Claws to him to settle him down and some cigarettes so that he would be able to leave them. Kyle, from there, realizes he's been separated from Mr. Balch. He goes over to the Ultimate gas station looking for Mr. Balch and is unable to find him. What happens next is he attempts to get back to Car Source at 59th and Sheridan Road. This is Kyle on the right coming into the frame. They don't let him pass. He goes back to the Ultimate gas station, and a few minutes later, at approximately 11:45, he receives a phone call from Dominic Black. Dominic Black informs him, the evidence will show, that they're breaking windows and starting fires down at Car Source 3. Go and stop them. He asks an individual for a fire extinguisher and asks the individual to go down to Car Source 3 with him. The individual gives him the fire extinguisher but does not go with him. And Kyle heads down to Car Source 3. He doesn't know that Mr. Rosenbaum is down there. He's been asked to go down there by Nick Smith. He heads down Sheridan from 60th, walking to Sheridan and 63rd where the Car Source is. That's a picture of him from a video leaving the Car Source at 11:46 p.m. approximately. He has his firearm, and he has, as you can see in his other hand, a fire extinguisher to put out the fires that are being started down there. This is an aerial photograph that the state had referred to in its opening, and it's actually started to roll, and you'll see circles in here. There's Kelly Zeminski in the green lettering, and that's a thermal image, excuse me. I don't think I get started. It starts very slowly. You can see, people are labeled Richard McGinnis, Richie McGinnis, and they head down. You see Mr. Rosenbaum come around from hiding in the cars, beginning to chase my client. You'll see the flash of the firearm from Mr. Zabitsky, and you'll see the flashes of his first shots. I'm not responsible for cutting this video. I don't know how it got the way it did chopped up. That's the FBI up in the plane that took this video. But it's very telling because you'll see this 100 times. I'm not going to go through it again for you in opening, but you'll see it that the individuals are heading down Sheridan Road, and you'll see this Mr. McGinnis is now over here, go and hide right in this location. You'll see Kyle come into this area and pause where Mr. and Mrs. Zeminski are, and you'll see in this car is a fire that started. You'll see how it's bright. And they go, Kyle runs in this direction, trying to get away from Mr. Rosenbaum. Ladies and gentlemen, Kyle Rittenhouse is under no obligation whatsoever to retreat from Mr. Rosenbaum. He does. He runs away from him because he doesn't want a confrontation. He doesn't want trouble, which makes no sense with what the state says about him hunting or chasing him down. He's trying to get away from the individual. You'll hear testimony, not just from Kyle Rittenhouse, but Balch, Mr. Balch, about Joseph Rosenbaum stating to Kyle and to Ryan Balch in each other's presence, if I get either of you two alone, I'm going to kill you. Flat out threats to murder. When Mr. Rosenbaum is shot in the car source lot 3, there's been a gunshot behind Kyle. He turns to address Mr. Rosenbaum with his firearm. Mr. Rosenbaum is not deterred. He continues to run. And you'll see that on numerous videos, closing the distance. Mr. Rosenbaum could have stopped at any time. Mr. Rosenbaum is wearing that maroon shirt on his face as a mask, covering up his identity, because he wants to steal my client's firearm and use it against him to carry out the threat he had made earlier. That isn't just the word of Kyle Rittenhouse made up after the fact. You'll hear the testimony of Richie McGinnis, who was close that evening. He was following behind them. You'll see him on the video. He'll testify to you in court. He did not feel endangered. He was doing his job. He will testify that Joseph Rosenbaum let out, as he put it, one of the scariest screams I ever heard, yelling, "Fuck you," and dove for Kyle Rittenhouse's gun. Kyle Rittenhouse fires. He fires 4 shots at Joseph Rosenbaum. The state wishes to slow everything down into a microsecond. Those 4 shots, the evidence will show, took 0.76 of a second, 76 hundredths of a second from first shot to last shot. Those shots will be those measurements will be put forth by Dr. John Black, who's a certified video examiner. He breaks every frame down. He knows how much each frame takes. He counts the frames, and he comes up with that time. Next photograph, 11:48. That's car source 3. You see an individual right here with his hand in the air. The evidence will show that's Mr. Zeminski. This is Mr. Rosenbaum in full stride running after Kyle Rittenhouse. This is a still from a video. And you'll see a lot of videos leading up to this. You'll see a video, I believe it's from Corey Elijah, where he's confronted by Mr. Rosenbaum. And he doesn't want a confrontation. And he goes, you'll hear it on the video. The video is not showing that confrontation, but you hear Kyle's voice, and he goes, friendly, friendly, friendly. He thinks, because he's giving medical attention and helping people out, that people don't have an animosity against him. He's wrong, but that's the belief in his head, and Mr. Rosenbaum chases after him. And I believe that the state will want to say, why did he go down there? He went down there because Nick Smith asked him to. Why didn't he keep running? One, you don't have to run. But two, I'll show you a video from 63rd looking back onto the car source lot, taken by an individual who will testify and his daughter. Next photograph, circled again, Zeminski with the arm up, Rosenbaum in full stride chasing, and an arrow pointing to Kyle. This is the video from 63rd and Sheridan Road.
Oh shit. They shooting. Oh shit. Oh my god. I am.
You'll see that whole video during the trial. The individuals were at Car Source, the rioters, destroying all of those vehicles. And as Kyle was running from Mr. Rosenbaum, he did not want to run into those rioters who were destroying all of that property that did not belong to them. You hear the first gunshot, the evidence will show Mr. Zeminski. You hear 4 shots in quick succession. The evidence will show that is Kyle firing at Mr. Rosenbaum as he's trying to take Kyle's weapon from him to use against him. You hear 3 more shots in quick succession. I don't think the government will have any dispute. I don't think the evidence will dispute. Those 3 shots are from another person who's in the Car Source lot firing for some reason. He was never identified, never arrested. This will show Kyle running back to the scene of the shooting. And it will show, I think the evidence will show, why Kyle Rittenhouse didn't stay and render aid for Mr. Rosenbaum. Not that he's under any obligation to do that, but sometimes discretion is the better part of valor.
He fucking shot him! Get him there! He fucking shot him! He fucking shot him! He fucking shot him!
Take screenshots. That dude shot him. That nigga just shot that dude! Cranium that boy! He just shot him, man!
The individuals who are yelling, he just shot him, shoot him, and you can see one of them with a gun, Mr. and Mrs. Zeminski. He begins running down Sheridan Road. He's not taking his gun. He's not threatening anyone as he's running down Sheridan Road. He's running in a southerly, I always get my directions confused, a northerly direction from 63rd towards 60th. What is at 60th? The evidence will show that is where law enforcement is, and that's where somebody would run to be protected from a mob that wants to kill him. The evidence will show this next video taken from Gage Groskowitz. He runs up to Kyle. At this point, he is unarmed. Kyle does not point a firearm at him, does not do anything to dissuade him from approaching him. You'll hear on the video the exchange, and you'll see it.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, stop him!
You see him running with the gun at the ground away from Mr. Groskowitz. Mr. Groskowitz came up on Kyle, got very close. Did Kyle point a firearm at him? Did Kyle shoot at him? No. All he wanted to do was get to the police. But the mob is closing in, of which Mr. Groskowitz is a member. The first individual runs up behind Kyle and hits him in the head with his hand, or a hand with a rock in it. This yellow circle shows Kyle being knocked a bit askew, but more importantly, his hat being knocked off. He's run all this distance, his hat stayed on his head. The government doesn't want anyone to think that he's being attacked or hit. This still photograph shows that his hat is being knocked off. That's the first blow to Mr. Rittenhouse. He continues to run. The testimony will show that these individuals are running up on him. What's important in this photograph, the evidence will show, is on the left, the testimony will be that Mr. Huber is picking up his skateboard. Why is his skateboard on the ground? Because he has taken his skateboard and swung it at Kyle Rittenhouse's head for the first time, hitting him in the head. And you can see in the blue circle Kyle Rittenhouse beginning to fall down. The two red marks are, one, the individual who struck him first, and Jump Kick Man closing in. Kyle goes to the ground. This is a still photo from a video you'll see. What's important here, the evidence will show, is an individual. Kyle's on the ground within 2 feet. Kyle points the firearm at him, does not fire. The individual backs up. He's no longer a threat. Kyle does not discharge his firearm. The next picture. The unidentified complaining witness, Jump Kick Man, kicking Kyle in the face. Behind Jump Kick Man is Huber. Now he's picked up his skateboard. This is a photograph from a different angle, a different individual. And you see him running in Kyle's direction. There's the boot right before contact. Those are the boots that struck Kyle Rittenhouse in the face. Here is the photograph. Mr. Huber's bare hand on the skateboard, holding the trucks, bringing it into contact with the back of Kyle Rittenhouse's head. Jump Kick Man still has not even gotten completely on the ground. And where is Mr. Huber's hand? And it's important here, ladies and gentlemen, it's a bare hand grabbing his gun. The state will produce evidence, I believe, that there's no DNA on the gun. He must not have touched it. Ladies and gentlemen, there's video photographic evidence of him touching the gun. Next, the bare hand pulling the gun towards him. Jump Kick Man getting up to run away. You can see a close-up, the bare hand on the gun. Kyle Rittenhouse flat on his back in the most vulnerable position one can be in. There, the strap is pulled tight. Mr. Huber's trying to pull the gun away from Kyle Rittenhouse as he's laying flat on his back. Kyle's afraid he's going to be disarmed and shot with his own weapon, the evidence will show. He fires one shot, striking Mr. Huber. In this photograph, just entering from the right, the evidence will show is Gage Groskowitz. One hand, a phone, one hand, a firearm. Here's Gage Groskowitz with his hands up. Kyle Rittenhouse does not fire. Look at the distance between them. Huber's skateboard has not even hit the ground yet. That's how fast all these things occur. Mr. Groskowitz does not stay in that position or back up. He moves in on Kyle, getting closer, pointing the gun almost directly at his head. As the state said, he's like this, but look at where the gun is going. The gun is in the circle. It hasn't got directly to pointing at Kyle's head, but it's going there. Kyle fires once, hitting him. Another individual approaches after Gage Grosskreutz has been shot, puts his hands up. Kyle Rittenhouse does nothing. In that in event number 2, the whole event from first shot with Mr. Grosskreutz, jump kick man coming in and getting the 2 shots, to the time Gage Grosskreutz is shot in the arm is about 5 seconds. You'll have exact times of those shots, how fast it occurs. And after the shooting that evening, Mr. Grosskreutz was interviewed. He told law enforcement his story of that evening. The one interesting detail he forgot to mention was that he was armed when he got shot. He told the police that he had lost his gun as he was running down Sheridan Avenue. He didn't know that there were people out there like him videotaping and photographing everything. He had a gun in his hand, and that's why he shot. His statement says that the reason he went into the fray was because he had to stop Anthony Huber from beating Kyle with the skateboard. At 11:51, Kyle has gotten up. There are individuals around who are in that area who've come at him. He's pointed his firearm, backed them off, and he continues in a northerly direction down Sheridan Road to 60th.
Hey, he just shot them! Hey, dude right here just shot them! Dude right here just shot all of them down there! That dude just shot them right there! That dude right here! Yeah! Someone injured straight ahead?
You see Kyle with his hands up approach the police car to turn himself in. The evidence will show that the police told him to get away from the car and go home. The police say that they pepper sprayed Kyle. Kyle didn't get hit with the pepper spray. He's not disputing that they might have shot pepper spray at him. That's why he backed up so quickly. He finally makes his way to car source 2 back at 59th, meets up with Dominic Black, the individual who sent him down to car source 3, tells him about what had happened. Dominic Black, I believe, will testify that he saw him. He was white as a ghost, sweating like a pig, and he was explaining what happened, saying he had to do it. It was self-defense. They talk about going home to Antioch. Dominic Black takes him home. They leave about 10 to 12, and at 1:20, Kyle Rittenhouse and his mother are walking into the Antioch Police Department, turning themselves in to the police, which is what he wanted to do here in Kenosha, but the way Kenosha was that night, with the police department surrounded by fence and things like that, he couldn't. He turned himself into law enforcement. He said from that day what he did. He's made no bones about that. He acted in self-defense, ladies and gentlemen. The evidence will show that his actions on August 25th of 2020 were reasonable under the circumstances as they existed that night, being attacked by Mr. Rosenbaum. The evidence will show, and the law is clear, he didn't endanger those other individuals. The government can refer to him all they wish as an active shooter. The only person he had shot was Joseph Rosenbaum, who had made threats to kill, had made numerous statements about ripping people's hearts out. He wasn't afraid to go back to jail. And Nathan DeBroom will testify to some of the actions of Mr. Rosenbaum that night. And he'll testify, and it was one of the more telling statements, I thought, in a statement. If there was trouble that night, Joseph Rosenbaum was there. And that's ultimately who visited himself upon Kyle Rittenhouse. The evidence will show he thought, probably, that he could get that gun from Kyle Rittenhouse. He was wrong. Kyle Rittenhouse protected himself, protected his firearm so it couldn't be taken, used against him or other people from Mr. Rosenbaum who'd made threats to kill, and the other individuals who didn't see that shooting attacked him in the street like an animal. Ladies and gentlemen, that's what the evidence will show. Thank you.
Thank you, Mr. Richards. Let's break for lunch, folks. I'm going to take a vote now, and I don't want to influence by phrasing it one way or another. Are you comfortable with the temperature here? I'm going to ask how many think it's too warm, just right, or too cool. So, how many think it is too warm in here? How many think it is just right in here? 2, 4, 6, pretty much everybody. How many think it's cold in here? All right. Well, the majority is going to rule, unfortunately. Okay, thank you. We have this blower up here, which on occasion I used to, and it's gotten progressively worse over the years in terms of its enormity and intensity, but it controls the entire building, so I can't shut it. I can't ask them to shut it down because it has control over the air throughout the entire building, and it's tied into what they did to the ceiling here in 1965 or so. All right, and with that, please don't talk about the case during the break. Is it unrealistic to set a tentative start time of about 1:15? But if you folks want more, that's okay. Just let me know if you want more time, and then we'll use this as a trial for the future. If you decide you wanted to go less time too, we could do that. But right now we'll aim for 1:15. And any questions? Okay, thank you very much.
Sorry. Hey, all right. How do we feel about that session there? I have one thing to say. Kyle Rittenhouse had to have been so scared. I mean, he's a child. And that was, even though he may have gone there with courage and tons of gumption to defend, once everything started going down, he had to have been so scared. Like, watching just those clips of the videos, I'm like, wow, that is really, really intense. Absolutely a horrific experience for a 17-year-old to have. I am 40 years old, and I have never killed anyone. I can't imagine what he must have been feeling for that to have happened. And then to be left, like, because even at the time, because the situation was so chaotic, like his lawyer was saying, the police just told him to get out of here and go home. They didn't even have the capability in the moment to hear what he had just done. He was trying to tell them. And they didn't even have, and even if they did have the capability, they didn't offer him that moment to hear what he had to say. So now he's carrying it with him. He hasn't even been able to tell the proper authorities what he's done. So now he's not only, you know, in this area where he's just like alone, now he's alone with this event that just took place. I just can't even fathom. I'm trying to fathom what he must have felt like as a kid in that situation. So heartbreaking. It's really heartbreaking. I just can't even I can't imagine what he went through that night and every night thereafter. He has to carry that burden with him for the rest of his life. You know? That's tough. That's really tough. I thought his lawyer did a good job. Can we just get a moment for Jump Kick Man? Like, who came up with that name? That's hilarious. Every time he says it, I'm like, really? And why did this guy, you have to wonder why this guy never came forward. Still to this day. You know he's watching this. And they're calling him Jump Kick Man. He's never come forward. Probably because he has a record. Probably because there'll be charges on him for something or another if he is to come forward. But can we just get a hand for whoever named him? Just so... There's so much going on in this this trial already. So funny. I thought the opening arguments, the way that they opened that up with just like arguments about whether or not to say what kind of hospital it was and whether or not to talk about why he couldn't stay with the woman and why the state wants to hammer the fact that he's carrying a certain kind of bag. I mean, if ever there were some nitpickers, but I feel like, I mean, I think the judge ruled that they won't be talking about that. Is that what I heard? Yeah. Yeah, imagine if it had been black people that he shot. Oh, gosh. It's exhausting to even think about. It's exhausting to even think about imagining that. Because it would have just been all kinds of crazy. I agree. I agree, Ireland. It would have been, I feel very mom-like thinking about Kyle. I feel it's, just right now, I feel mom-like thinking about what he must have been going through. Just so crazy. Yellow Pants Man, too. Arguing over open. Not gonna lie. Did anybody notice the prosecution admitted on nationwide TV that those were riots? I did hear that. It struck me as odd. I was like, huh. Yeah. About time. About time. Oh, the judge is going to revisit it. Okay. Yeah, I feel, it seems as though, I mean, I'm trying to figure out why, if this guy just got released from hospital, I don't care what kind of hospital it was, why is he participating in a riot with a hospital bag? And I also think it's absolutely ridiculous. See, part of the problem is that Antifa and everybody like them and all those who support them are seriously the most professional victims on earth. They are professional victims. And it is absolutely ridiculous to listen to them moan and groan and whine and cry about circumstances they created. So they're chasing Kyle down. They're being absolute jerks, crazy people. Kyle responds, and then all of a sudden, oh my gosh, there's an active shooter, and we need to disarm him and do this and do that. Excuse me, but this wouldn't be happening if you weren't acting like complete boneheads out there. They create the situation, and all of a sudden they want to turn around and act like the victim of the situation. It's just, nobody is allowed, in their mind, nobody is allowed to defend themselves against their mental issues and their violence and their hate and their crime. You're not allowed to defend yourself against all of that. Because as soon as you defend yourselves against all of that, it's just, all of a sudden they're the victim. It's crazy. Anyways, I don't know. It's just crazy. All of it's crazy. Okay. So they're to lunch. I didn't hear. Was it, how long is the lunch? An hour? So they'll be back at, yesterday it was 1:30. 2 hours ahead. Are they coming back at 1:30 again? Like Dustin crying over Sixers. 3 days after they attacked us with explosives and he played the victim. Absolutely. That is such a dynamic example. This grown man was losing it over stickers. And yet he called us dangerous after they were just throwing explosives at us. Babies. Including babies. Yeah. 45 minutes. Okay. 1:15. Okay, so I think everybody should take a break maybe. I'm going to take a break. I've been working this the whole time. The boys are actually with Grammy right now. My daughter is still sleeping. It's always amazing to me when a majority of the kids leave and there's one left, whether it be our daughter or one of the boys or whatever. It's amazing to me how long they sleep when they are in fact uninterrupted by all the chaos that ensues the moment one gets up and then the next and then the next. Like Apollo, he sleeps for a really long time too when his brothers aren't here. And apparently Rain sleeps for a really long time too when her brothers aren't here because they're super loud and disruptive. So that's that. Okay, 1:15. So I will see you guys back here at probably a little bit like 1:10 or so. And I'm going to get couple things done. I've been working this whole time. Oh, just as a reminder, guys, there are some new shirts up. I haven't got a really neat design or whatever to show you or whatever, but this is them right now. Everything woke turns to Let's Go Brandon because this is the more PG version of it. And then this women's Terry sweatshirt, which I've heard is very comfortable. Mine is on the way, so I haven't been able to wear it yet. And Let's Go Brandon Ditch 46. So these are the new shirts in the website at thebcpreacher.com. If you are interested. And I will see you guys back here at 1:10. Gonna grab some lunch and settle everything up. All right. See you guys soon. All right, we're back online. We are covering the Kyle Rittenhouse trial here on the BC Preacher. If you're new here, like, subscribe, and share. And make sure when you subscribe, you hit that notification bell and select all notifications, or you'll have to depend on Facebook and YouTube to decide when you should receive a notification, when you shouldn't. So if you want to receive them all, make sure you hit the notification bell and select all. I will be your host during this trial. So, sorry about that. BCP is hard at work at his day job, so I'm going to take the wheel here. They should be getting back in session in about 3 minutes or so. A couple of things. Let's see. We've got new merchandise in the store. Let's Go Brandon. I love that it's a PG version of what we all feel about this administration. So, Let's Go Brandon merchandise in the store, new stuff. There's actually a lot of Let's Go Brandon stuff. I just got my Let's Go Brandon apron the other day, so I'm excited. And also, if you guys have ordered merch and you want to take pictures and send them to the bcpreacher@gmail.com, that would be amazing. We'd love to see it and share it. So there's that. Oh, no sound? You can't hear me? Am I just talking by myself, or are you, Michael, are you being ornery, or you really can't hear me? Oh, okay. Thank you so much, guys, for joining for the trial, so we can watch it together and talk about it and all that good stuff. It's been interesting so far, and we just look forward to
fully explainable
see
by
what's
their baseline COVID infection rate.
Oh, they're back on.
Higher in Hispanics. That is partially explained by their baseline COVID infection rates in the population. And for the others, not enough data to really make strong determinations. For the myocarditis after vaccination, I can say that most of the cases for which we know the
Hold on one second. I'm not sure what this is.
Does actually tend to be more often white.
Something just popped up regarding that's not what that's not it. That was a random thing that popped up. They should be coming in a minute or so with the actual footage. That was something else. Okay, we didn't miss anything. Anyways, okay, moving on. Things happen. Yeah, you know what? I don't typically wear an apron, but Let's Go Brandon apron seemed fun. Besides, my kids love it. And that's that. And if you guys want to get hooked up on Discord, lots of stuff on Discord conversation and tons of great articles and news going on there. Our very own Witchy is a super curator of all things newsworthy. So that is awesome. If somebody wants to post the Discord link, I know it's been posted earlier before, but if you have it on hand, that would be amazing. Please. Thank you, mods. You're doing great. Apparently, Julie got banned for saying that the judge was a constitutionalist. She got a strike or some warnings or whatnot, which is ridiculous. I'm not exactly sure, but what is this? Yeah, it goes against community standards to say that the judge is a constitutionalist. So, we're not going to see. I'm not sure how many days. I don't know how many days she got banned. I don't think she can comment. So frustrating. The little lady is awake, so that is good. And we are still waiting on them to come in back from lunch. Need to get the fact checkers a dictionary. Absolutely. Yeah, they need more than a dictionary. They need mental help. All right. So, let's see. Today is Tuesday, November 2nd. We are covering the Kyle Rittenhouse trial of him during the riots following the death of Jacob Blake. I believe he was the one who reached for a knife in his car. He was at like a significant other's home where he had a restraining order against him. He shouldn't have been there to begin with. Speaking of shouldn't have been there to begin with, I mean, they're talking about why was Kyle Rittenhouse in this place. So, I mean, he could be wherever he wants. He didn't have any restrictions, whereas Jacob Blake, he actually had a restraining order against him. He shouldn't have been where he was at. And he reached in and for a knife and was shot. I believe that's him. Is that the guy? And following that, riots broke out, and Kyle was in a very dangerous situation and had to defend himself against the terror of people coming at him and kicking him and hitting him and all that stuff. So she was banned from commenting. Julie was banned from commenting for providing the information that the judge of this case seemed to be a constitutionalist. That apparently was a went against community standards. But it doesn't seem to say how long it'll be before she can comment again. It's ridiculous, y'all. It's absolutely ridiculous. Please like, share, and subscribe. It is free to do so. Sharing is a huge, huge help to the channel. Just remember that we're trying to keep the channel up and running. Yeah, the judge just has to be fair. It's not really even up to the judge. It's up to the jury. So she was just saying that she thought that the judge seemed like a constitutionalist. But it's really not even up to the judge. It's up to the jury. I like the judge because he has humor. And I always like humor. A day without laughter is a day wasted, my mom says. So. Let's see. I think they're late, guys. I think they're late. They might not be coming until 1:30. Okay, well, the little lady is awake and she's eating. So I'm going to go check on her and I will be back.
Was that the same period of time that you were dating his sister?
Yes.
And how frequently would you see the defendant during those 9 or so months?
About every day.
You mentioned there were times when you would go down to his residence in Antioch, is that right?
Yes.
Were there times when he would come to your stepfather's residence here in Kenosha?
Yes.
How often would that occur?
Weekly.
What sort of things did the two of you like to do together?
Everything as a kid. Hanging out, going to the lake, hunting, going up north, just everything you would do growing up.
You mentioned hunting. Is that something that you and your family are interested in?
Yes.
Tell us more about that.
We own property in Ladysmith. Every year growing up, I would go there with my stepdad and my brother and go hunt ever since I was a little kid.
When you say hunt, what sort of things would you hunt?
Deer, turkey, pheasant, rabbit.
Can you describe your family's property in Ladysmith for us?
Yeah, it's about, I want to say 13 acres of land with somewhat we would call a shooting range, which is like a big open gravel pit, and it's pretty secluded and private in the woods.
Now you mentioned that the defendant was interested in hunting. Did you ever bring him along hunting up in Ladysmith?
I wouldn't say hunting. We did bring him once to go kind of just get a feel for hunting and shoot guns and just kind of get away for the weekend.
Do you remember when that was?
I would like to say a few months before everything happened.
If I said it was in early May, around May 1st of 2020, would that sound right to you?
Yes.
Now, do you remember a time in which you and the defendant were up in Ladysmith and there was some discussion about purchasing a gun?
Yes.
Can you tell us about that?
We were going up and we had stopped at a store that was local to buy like clay pigeons and ammo. Kyle had also wanted a gun similar to the one I had. He did not, or I did not have the money for it, so he said he would pay for it. I told him that wasn't a good idea. He wasn't 18, but we came to an agreement to where he could have it once he is 18. It would be kept at my house until then, so it kind of went on from there.
What kind of gun was this?
An AR-15.
Did you have one of those already?
Yes.
Did the defendant see that gun that you had?
Yes.
How did it come to be that he saw that gun?
Just from when I bought it, he had saw it at my house, or, just me opening it from the box.
And he indicated to you that he wanted a similar type gun?
Yes.
Did the defendant say anything to you about why he wanted such a gun?
No.
Now, you just mentioned the fact that the defendant was not 18. How old was he in May to August of 2020?
17.
And you discussed that he couldn't have a gun because he was 18. Is that something that you and the defendant actually talked about?
Yes.
Can you tell us about those discussions?
It was more along the lines of he would be 18 soon. I told him I didn't want to do it because I knew it wasn't, obviously he can't buy it legally. We did agree that it wouldn't be his until he was 18, and he was aware of that. And from then on, it did stay at my house.
So when you were up in Ladysmith, I think you said you went to a local store to purchase the gun. Is that correct?
Yes.
In whose name was the gun purchased?
Mine.
So you were the legal registered owner of the gun?
Yes.
Where did the money come from to get that gun?
Kyle.
After the gun was purchased in Ladysmith, did the defendant use it?
Yes.
Tell us about that.
We just target practiced. We bought a pretty good amount of ammo and just shot clay pigeons, and just went into the woods on our property.
Now, you mentioned earlier there was some sort of, I think you said a shooting range on the property. Is
Yes.
that right? Can you describe that for us, please?
It's about 250 yards long. It's an old gravel pit that they used to use to obviously get gravel. It kind of just turned into the shooting range for us. As a big open field.
Did you and the defendant shoot your AR-15s on that shooting range?
Yes.
You mentioned it was about 250 yards long. Did you have targets that far away?
Not entirely. It was, more at the time it was just like iron sights, so that wasn't a realistic range to shoot. We would set up clay pigeons hanging on trees at the end of the range and just kind of walk a certain amount of distance until we felt comfortable it was the right spot.
What would you say the farthest distance away would be that you shot targets at with your guns?
Say about 75 yards.
Were you successful in hitting what you were shooting at?
Not all the time.
I'm going to ask the detectives here to show you a couple of exhibits that have been marked as exhibits 27 and 28. And I'm going to have them handle them for safety purposes, but I'm going to have them hold them up and show them to you, and I'm going to ask you if you can identify them for us, okay?
Okay.
And I want to represent to everyone that these items are not loaded. There are no bullets or anything like that. I believe that Detective Antaramian is holding up what is been marked as exhibit number 27. Detective, is that right? That's number 27? 27. Okay. Do you recognize that item, Mr. Black?
Yes.
What is that?
One of the AR-15s.
Do you know which one that is?
I believe it's Kyle's. I'm not too sure.
Okay. Would it be fair to say that yours and the defendant's look very similar to one another?
Yes.
Do you remember if there are any particular markings on one or the other that would help you to identify them?
The only difference was the sights.
What was the difference in the sights?
One of us had a bigger one. I don't remember which one it was.
Okay. I'll have the detective now show you the next exhibit, which is exhibit number 28. Detective Antaramian is now showing you another item, which is exhibit number 28. Do you recognize that?
Not from the last time I've seen both of them, no.
Okay. And I noticed that the gun that he's holding up doesn't appear to have a scope on it. Is that right?
Yeah.
Okay. Are AR-15s the type of weapon where a scope could be added to them if need be?
Yes.
Okay. Thank you, Detective. Okay. Could you grab that, please? Detective Antaramian indicates there's a scope in the box, so we're going to show that to you as well. Maybe we could show Mr. Black both of the scopes, and you could tell us if you recognize which one might be yours. So, I believe Detective Antaramian is showing you one of the scopes. Are you able to recognize if that's yours or the defendant's?
That is not mine.
Okay. So that scope came, you believe, from the defendant's gun?
Yes.
Okay. And if you recall, thank you, Detective, the other weapon that we had that had a scope on it, now that you've seen this other scope, does that help you remember which gun was which?
Yes.
Okay. The other gun that we showed you, which is Exhibit 27 with the scope attached on it, was that your gun?
Yes.
Okay. So these two exhibits, 27 and 28, are, 27 is the first one is your AR-15, and the second one is the defendant's. Is that correct?
Yes.
Your Honor, I'd move exhibits 27 and 28 into evidence.
No objection, Your Honor. Received.
Can you help us understand, Mr. Black, why you were interested in having an AR-15?
I kind of wanted like a personal project. I had mostly only had hunting guns, and I wanted to try something new to target shoot. I have a lot of family with guns like that. They kind of find it a hobby to build them up and put different attachments on them, so I figured I would try and get into it as well.
How long had you owned that AR-15?
I want to say 2-3 months.
Before May or before August?
Before May.
Okay. And in that time period, had you made any modifications or additions to the gun?
Just the scope.
I assume if life had kept going forward like normal, you would have continued to do so?
Yes.
Okay. We're going to talk a little bit in a few minutes about the night of August 25th. Other than that night, was there ever a time in which you went out in Kenosha holding or carrying that AR-15?
No.
How would you normally store or carry around that weapon if you did?
In my arms. I mean, if I'm driving, it would be, disassembled in the back of the car, unloaded.
Maybe I was not clear on my question. I believe you said that up until the night of August 25th, you hadn't went out armed with that AR-15 in Kenosha. Is that fair to say?
Yes.
When you did have it with you in Kenosha, was it disassembled in the trunk of your car?
On the way there, yes, but once we had arrived, no.
Where did you normally keep your gun on a daily basis?
Locked up inside the house.
Whereabouts inside the house?
In the safe.
Where was that safe located?
In my dad's room.
Did you have a key to that safe?
No.
Who did?
My dad.
When you wanted to get your AR-15, did you have to get your dad's permission?
Yes.
And just so we're clear, when you say dad, that's technically your stepdad?
Yes.
Okay. So, for example, in May when you went up to Ladysmith with the defendant, who all came along with you?
It was me, Kyle, my brother Ray, my friend Cody, and Kyle's sister.
Do you remember approximately how long you spent up there?
I want to say it was the weekend.
When you went up there, I assume you brought your AR-15.
Yes.
Did anyone else bring any other guns along with them?
Yes. We also brought like a 12-gauge hunting shotgun, and then I think my friend brought his little .22 pistol.
And I think you said earlier that your dad, your stepdad, and your brother were also interested in hunting?
Yes.
Do you recall approximately how many rounds you and the defendant would have fired off at that firing range up at the property in Ladysmith when you were there that weekend?
A lot, I would say 100, 200.
May I approach, Your Honor? Mr. Black, I'm going to show you a document which has been marked as exhibit number 7. Do you recognize the photograph on that document?
Yes.
Who is shown in that photograph?
Kyle.
Was that a photograph that was taken when you and the defendant were up in Ladysmith around May 1st of 2020?
Yes.
Does that photograph show the defendant holding his AR-15?
Yes.
Your Honor, I'd move exhibit number 7 into evidence.
Is there objection?
No.
Received.
May I publish that to the jury, Your Honor, on the screens?
You may.
Sometimes these TVs are too smart for us. Could you turn that one on too, Natalie? And then could you input for number 1, please? Sorry, I'll do it. Mr. Black, do you recall what day that photograph was taken when you were up there?
I want to say the same day we arrived.
Does that photograph show in the background there the property that your family had up in Ladysmith?
Yes.
Okay. And do you remember who it was who actually took that photograph?
Yes.
Who was it?
My friend Cody.
Do you remember if that was before or after you and the defendant went to the firing range and
This is before.
practiced? Okay. All right. Thank you. Now, after you and the defendant returned to Kenosha from Ladysmith, and the defendant, that you purchased this gun for the defendant, what happened to the gun after that?
It was locked up in the safe.
Which safe is that?
The one in the garage. It was the one that required a code to open.
That's the garage at your father's place?
Yes.
Here in Kenosha?
Yes.
Stepfather? I'm going to use that interchangeably, but technically that's your stepfather, correct?
Yes.
Okay. Thank you, Judge. Did you have a code to open that safe?
No.
Who did?
Only my stepdad.
So the defendant didn't either?
No.
Why didn't the defendant take that AR-15 back to Antioch with him?
Because we had an agreement that he wouldn't do that.
What was the reason why?
He was 17.
Was the defendant accepting of that? Did he understand that?
Yes.
Do you recall having any discussions with his mom about that?
Not me personally.
I want to talk about the time period between when you came back from Ladysmith in early May and the night of August 25th, 2020. In that period of time, did the defendant ever possess that AR-15?
No.
On the day of August 25th, 2020, the day when all this stuff happened, did he possess that gun?
Yes.
How did it come to be that he gained possession of that gun on August 25th?
My dad had took a lot of the weapons we had out of the safe due to all the rioting and stashed them inside the house in case somebody were to come break into our house. And that gun happened to be one of those weapons.
Do you know how the defendant took possession of it that day?
I do not. All I'm aware of is that it was downstairs.
When did you first see the defendant with that weapon that day?
When I was in the kitchen. So about, I want to say, a few hours before we left.
And tell us what you saw when you were in the kitchen.
I saw him coming up the stairs with it.
With the AR-15?
Yes.
Did you hear him ask you permission to take that gun?
No.
Did you hear him ask permission from your father?
No.
When the defendant came upstairs with that gun, what, if anything, did he do with it?
I believe he set it down on the table and started looking for medical supplies.
What do you mean by medical supplies?
Like bandages, rubbing alcohol, certain things like that.
Do you know why he was doing that?
Yes, in case somebody was hurt downtown.
We've seen some photographs that night of the defendant with a bag that looks like a medic bag. Do you remember him having that night?
Yes.
One that night? Do you know what was in that bag?
All the medical supplies that he was gathering.
Were those medical supplies gathered from your house?
Yes.
Do you know if the defendant got any medical supplies from Walgreens or any other store or anything like that, or was it just all from your house?
I know there wasn't any from any store, but I'm unaware of anything that happened after we had got to the lake.
Okay. So I believe you described that the defendant took the gun into the kitchen, put it on the table. He was gathering some medical supplies. Is that fair to say?
Yes.
What happened after that?
We proceeded to get ready, and then we went down to the lake.
When you say we, who do you mean?
Me and Kyle.
Where did you go when you went down by the lake?
At first we had parked by a friend's house, and then we walked to, I want to say, the back parking lot of Ruther.
And what did you do there?
We met up with our friend Nick, and then we proceeded to go to the car source locations.
When you say Nick, do you mean Nick Smith?
Yes.
When you say car source locations, we've heard some testimony about 3 different locations. Can you help us to understand which one you're talking about?
The first one we went to was the one that would be closest to us right now, so further south.
I apologize, I was a little distracted there. Can you tell me again, which was the first one you went to?
The one that was further south.
63rd and Sheridan, does that sound right? And when you say we went there, was that the defendant, you and Nick Smith?
Yes.
What happened then?
Then we met the owner once again, and he gave us a ride to the north location and dropped us off.
Okay, I'm sorry. You say you met the owner once again. When was the first time that you met him?
Previously in the day, I want to say it was around morning time when we were cleaning up all the graffiti.
So maybe I've jumped around a little bit, so I want to make things clear. If I could have just 1 second. Let's start. I apologize, it's my fault. I kind of jumped in the middle of the day. So I want to start at the beginning of that day. That was Tuesday, August 25th, 2020, the day that all these things happened. So let me back up for a little bit so we can kind of go in chronological order. I think it's easier for everybody to follow. The night, Monday night into Tuesday, did you stay at your own home?
Yes.
Did the defendant stay there as well?
I do not recall.
Do you remember when the first time would have been that you would have seen him on Tuesday morning?
I don't know specifically what time, but it was before noon.
When you saw him, was it at your house?
Yes.
What happened when you first saw him? What did the two of you do?
Me, him, and my brother Ray decided to go down to the lake and kind of just look at how things were, and then from there on we decided to help clean.
When you say you went down to the lake, do you mean the actual beach lakefront, or do you mean downtown?
Downtown.
Where did you go when you went downtown the first time?
We parked right next to the car source location that had already been burnt down, and then we walked across Sheridan to Ruther.
I'm gonna, may I approach, Your Honor? I have a map here of the area, and I'm gonna try and prop it in such a way that we can all see it. I wish I had an easel, but I don't right now. Mr. Black, I'll be a human easel for a moment. This shows the area of downtown beginning on the north at 58th Street and going down to the south at 63rd Street. Sorry, Karen. And the area along Sheridan Road there. Do you see that, Mr. Black?
Yes.
Okay. Now,
I'm going to ask you that, what happened to our easel, do we know?
Well, they're
Back here?
upstairs.
Okay, and then put it, because right now the defendant can't see it, and I'm required to ensure that he does, and also I can't see it either. Now, and then also, once we get that, then
okay. Which way, is that okay? Can we
we're
wait
waiting
that?
for the easel. And
Yeah.
you can continue with examination on something else,
It's
or you
right
can
here.
wait. There we are. Put it back so that the defendant can see it.
Or up there.
Can we maybe
Or up
angle
there.
it up there?
That's
Would that be
actually what
okay?
we use.
Yeah.
Yeah, use that.
There's a button here to push, so maybe do some marking here in a sec. Okay, thank you, Judge. This makes it a lot easier. Mr. Black, I put a little laser pointer right in front of you there. Could you use that and show us on this map? I'm going to focus in on the first time you say you came down with the defendant. And I think you said, was there anyone else with you the first time, or was it just the two of you?
No, it was me, him, and my brother.
Okay.
There's another if you like. No, then you could
Oh.
if you want.
Yeah.
Or you can use the one Sister Mercian gave me.
I don't want to be accused of using a dangerous weapon, so I'll use just the laser pointer here. So, thank you. Sure, I know how to turn it on now. Oh, there's the button. Okay. Could you please use that laser pointer and show us on this map? You said you parked near one of the car source locations when you first came down.
Yes.
Can you point out where that was?
About right. Say right here.
And for the record, you are pointing to an area that is, I believe, on 59th Street, just east of Sheridan Road. Is that correct?
Yes.
And on this map, there's a label there of one of the car source locations at that intersection, at that corner. Do you see that?
Yes.
Okay. You described one of the car source locations as one that had been affected by the events of the previous night. And I'm not sure what word you exactly used, but can you describe for us, when you were at that particular car source location, which is on the northeast corner of 59th and Sheridan, what did you observe?
Every car was burnt to ash. There was a lot of garbage and graffiti everywhere.
Now, there's a structure on that property, an office of some sort. Did you observe that office as well?
Yes, it was burnt down.
Did you look inside?
No.
Is it fair to say that every car in that lot was burned to the chassis almost?
Yes.
Okay. Now, you indicated you parked near there and looked at that location. Is that correct?
Yes.
What did you do next?
From then we walked to, which is now Harborside.
And on that map, can you show us where that would be?
I don't know if it's on the map exactly, but it would be more south up there.
And when you say south, you mean actually north?
Yeah.
Okay.
Yeah, I'm sorry.
So you're talking about the area near Ruther High School?
Yes.
Which would be right across the square from where we're at right now?
Yes.
And why was it that you walked in that direction?
We noticed there was people cleaning the graffiti, and that was my old school, so we decided to go help.
Did you help?
Yes.
And what did you do to help?
Scrubbed the walls.
Did the defendant help as well?
Yes.
And how much time did you spend doing that?
I want to say 2 hours, about 2.5 hours.
Did you have any supplies on your own to use to clean, or did people already have some?
They had some. I personally left by myself to go get sandpaper, and then I came back to try it.
I've never tried to clean graffiti off a wall. How does it work?
Not very well.
Well, I appreciate your efforts. What happened then after that?
From then we went back to the house and went home.
So you got back in your car and drove back to your house?
Yes.
And your brother came along?
Yes.
What happened then?
From then, that's when we ended up getting the guns.
Now, we talked earlier about a time in which the defendant came upstairs into the kitchen with his gun. He started to gather some medical supplies. Are we at that point in the chronology?
Yes.
Okay, good. Just want to make sure I've got everything in order. Then let's go forward from there. What happened after the defendant was gathering medical supplies? He had the gun in the kitchen. What happened then?
As soon as we were ready, we went down to the lake, and that's when we parked at Nick Smith's house.
And I don't know if it is on that map or not. Is his house located somewhere in that area?
Yeah, it's not on the map, but it would be if the map was up more.
Okay. If the map was up
If
more?
the map were up more, yes.
Okay. So your friend Nick Smith lives somewhere near this area. Is that fair to say?
Yeah, behind Ruther.
Okay. And you went to his house. Is that right?
Yes.
Who came with you?
Just me and Kyle.
Did you have your guns?
Yes.
Did you have any ammunition for your gun?
Yes.
You personally?
Yes.
Do you know if the defendant did?
Yes.
We've had some discussions at various points already in this case about a strap or some sort of device for retaining the gun. Did you have that type of item with you?
Yes.
And did the defendant?
Yes.
Do you know how those were, how you acquired those?
Yes, from Jelinski's.
When did you do that?
I want to say the middle of that day, in between us getting back from cleaning up graffiti and before we left.
So earlier you described coming down, looking at the burnt out car source location, going over to Harborside or Ruther and cleaning up some graffiti, and then leaving the downtown area. Is
Yes.
that right? Is that when you went to Jelinski's?
We did stop at the house first, and then I believe it was like an hour until we did go to Jelinski's.
When you say we, who all went to Jelinski's?
Just me and Kyle.
What was your purpose in going there?
To get a sling,
Why did you want a sling?
so we didn't have to hold it the entire time we were walking.
Do you recall if you and the defendant both got the same kind of sling?
Yes, we did.
Who actually went in and purchased the sling?
Kyle.
And after that, leaving Jelinski's, did you then go back home again?
Yes.
And that's when you acquired, or the defendant acquired the gun and the medical supplies?
Yes.
Okay. And then after that, you said you came back down to the lakefront. Is that right?
Yes.
Where did you go when you came back?
We went to Nick Smith's, and then we met him at the Ruther parking lot, and from then on we walked to the car's first location.
Now, I want to stop you for a second because you made a mention earlier of the owner of CarSource. Do you know that person's name?
I believe his name was Sam.
When, if at all, did you encounter him on that particular day?
We encountered him twice that day. The first time when we were cleaning graffiti, on our way back to the car, when we were leaving, we stopped and talked to him. And then after we had met with Nick later that day, he had brought us to CarSource to meet with him again.
So let's talk about the first time. You described cleaning graffiti at Ruther, which is kind of at the north end of this map. Is that fair to say?
Yes.
And then you encountered this Sam on your way back to your car, which I believe you said was parked at 58th and Sheridan by that first CarSource location.
Yes.
Where in that process did you physically meet Sam?
On the corner next to CarSource, not the one that had originally got burnt down, but the next one over across the street.
Can you please use your pointer to show us where that was?
About right at the corner right there.
You're pointing to the southwest corner of the intersection of 59th and Sheridan, is that right?
Yes.
Now, did you, at this particular moment when you were meeting with Sam that day, did you observe the condition of that particular car source location?
Yes.
How did it appear to you?
It wasn't entirely destroyed, but there were some cars that were damaged.
When you say damaged, what did the damage look like?
Like kicked in doors and hoods and shattered windshields.
Did there appear to be any fire damage?
No.
What about the building? Did you make any observations of that?
It was just boarded up.
Okay. And when you talked to Sam that first time, this first conversation, what did you talk about?
We basically just talked about the defamation that he had in his last, the one that had actually burnt down, and how much money he lost, and how deeply he would be in case all his other buildings did burn down.
And was there anything more that you talked about with him?
We did exchange phone numbers in case he needed any help.
Did you feel at that point like you wanted to help him?
I mean, my help was definitely there, but I didn't offer any help at that point.
Do you know if the defendant did?
I'm not aware.
And when you say exchange phone numbers with Sam, did you personally give him your number?
Yes.
Do you know if the defendant did?
Yes.
And then you said, we're going to fast forward a little bit because we've covered some of the intervening time period. You said at some point you came back down later, you parked at Nick Smith's house, and I think you said you went to the Ruther parking lot?
Yes.
And then at some point you said you went down to Car Source, is that right?
Yes.
Which Car Source did you go to after you left the Ruther parking lot?
The one that would be closest to Ruther, on the same side of Sheridan.
Is it that same one we were just talking about on the southwest corner of 59th and Sheridan?
Yes.
Now, do you recall approximately what time of day it was that you came back downtown?
I'd say around 5 p.m.
And you and the defendant both had your guns with you?
Yes.
And those straps?
Yes.
And I believe you said you had ammo too?
Yes.
Okay. When you met with Nick Smith in the Ruther parking lot, was there anyone else there besides the three of you?
There was some other people that we didn't know that had also showed up.
And from there, you said you walked to the Car Source at 59th and Sheridan?
Yes.
Why did you go there?
We were kind of just following Nick. About halfway there, we found out that we were meeting the owner Sam again.
Did you actually meet the owner Sam again?
We met his brother, so the other owner.
Where physically on that map, can you use the pointer to show us where you actually met with the brother?
Right there.
So you're pointing again to that same Car Source at 59th and Sheridan?
Yes.
On the southwest corner?
Yes.
Was, when you met with him, do you remember, were you in the building? Were you outside?
We were outside.
Okay. Do you remember what you talked about?
We just talked about pretty much how to get in if we needed to, and then Nick had brought up if there was any way to get on the roof, and if there was any keys we needed to get inside.
Why were you having this discussion with the brother at that time?
Pretty much just to know where to stand, to make sure that a lot of us were safe and what we were allowed to do, and if we were allowed to go inside the building in case something happened.
So it sounds like there was some discussion of physically staying at that location.
Yes.
Why?
That's one of the locations we didn't want to end up burning down.
Was it your intention then to stay and protect that Car Source location?
Yes.
Was that something that the defendant was also planning to do, as far as you know?
Yes.
What about Nick Smith? Him too?
Yes.
Now, when the three of you, the defendant, and Nick Smith meet with this brother at that Car Source at that time, was there anyone else involved in protecting that location at that time?
Just the people we had previously met with at Ruther. They weren't exactly in the conversation with who was going where at the time.
What happened after you met with the brother at that Car Source?
Me, Kyle, and Nick had got a ride from the brother to the, I want to say, south location, and then he had dropped us off there.
Could you please use your laser pointer to show us on the map where the south location is that you're talking about? And you're pointing to the Car Source location that is at the northwest corner of 63rd and Sheridan, is that right?
Yes.
And you said the brother gave you a ride in his car down there?
Yes.
When you got down there, did the brother stick around or did he leave?
He stayed for about 30 minutes and then he left.
Did you meet with anyone else down there?
Yeah, that's when a lot of people that we didn't really know had came from out of town and other cities to come help.
Do you, as you sit here today, do you remember the names of any of those people?
Very few.
What was going to be the plan for that night?
The plan was to have a decent amount of us split up between the two locations and then kind of stay there to make sure nothing bad happened.
Which location were you going to go to?
The one closest to Ruther.
The one up at 59th?
Yes.
What about the defendant?
He was going with me.
So the two of you were going to be assigned to protect the 59th Street car source?
Yes.
Was there another group that was going to be assigned to guard the 63rd Street car source?
Yes.
Do you know who any of those people were?
No.
Were those people there in person when you guys were making these plans?
Yes.
So as far as you could tell, everybody understood who was going to be at one location and who was going to be at the other?
Yes.
What did you do next?
Then we walked to the car source location closest to Ruther.
Once you got there, is that where you personally stayed for the rest of the night?
Yes.
And again, you had your gun?
Yes.
And the defendant had his as well?
Yes.
Tell us about what you did when you were at 59th Street car source.
I had climbed the ladder and got on the roof of the building to kind of just watch out for people, and that's kind of where I stayed all night.
Why did you decide to go up on the roof?
I kind of didn't want to be in the mix of a lot of problems. I didn't want to, I didn't want to get hurt. I didn't want to cause any problems. I figured it would be a lot safer up on top.
Why did you bring your gun?
In case something bad did happen and I needed to protect myself.
When you say something bad happened, what were you worried about happening?
Anything. Being shot at, somebody coming up on the roof. I mean, there's a ladder in the back, so anybody could get up. Anything.
So if someone climbed up on the roof, were you going to use that gun?
Not really. I mean, it depends what they were doing.
You talked about not wanting to be on the ground because of your concern about things happening on the ground. Did you feel that if you stayed on the ground, you would be in greater danger?
Yes.
Why was that?
People could easily get access to hurting me or coming up closer to me.
When you say people, who were you
Anyone.
worried about?
Anyone riding, anybody that was there for the wrong intentions.
So, what got it in your mind that night that you felt there would be people out on the street that would want to hurt you if you were down on the ground?
I had heard about the previous night and how it was, and I knew that there was a lot of people fighting each other and a lot of violence. So I felt it would be best that I went there, if I was going to go there, making sure that I could protect myself if I needed to.
But you were also there to protect the car source location.
Yes.
How were you going to do that from up on the roof?
I'm helping anybody else that was there. I'm spotting people that were throwing things.
And then what? If you see somebody throwing something, you had a gun, were you planning on shooting them?
No. I mean, when somebody sees a weapon, they're not going to want to start any problems, obviously. If I see somebody with a weapon, I'm not going to want to initiate a problem.
Was it part of your thought process that night that by having the type of weapon you did, that it would deter others from attacking you?
That's fair to say.
Were there others in your group at 59th Street Car Source besides the defendant who were similarly armed?
Yes.
How many?
Everybody except for one person.
And when you say everybody, how many people are we talking about?
6 or 7.
So it's fair to say that there were, other than you and the defendant, there were another 6 or 7 people that were all carrying AR-15 type weapons?
Yes.
When you were up on the roof that night, what observations, if any, did you make about the crowd and what was going on the ground?
There's a lot of violence, a lot of screaming, a lot of people throwing things. You could definitely tell that people weren't just there for the reason they were. It wasn't a safe place to be at all.
Now, I'm going to ask you a little bit about the timing of that evening. And I'll represent to you that at some point in the evening there were crowds right out front of this courthouse and then there were crowds that were pushed south on Sheridan. Do you remember anything like that?
Yes.
Can you tell us in your own words, when you first got to CarSource at 59th Street, was there a lot of people out in front of the building on the street?
No.
Did that change?
Yes.
Tell us about that.
Later through on the night, the crowd got pushed back closer and closer to us.
And we say pushed back. Who was pushing them back?
The police.
And how were they doing that?
With the big trucks and a lot of rubber bullets and.
The crowd that was being pushed back, what was their behavior like when they passed in front of your location?
Very violent, very upset.
When you say violent, can you give us examples of the type of violence you saw?
Saying a lot of threats, throwing a lot of things, a lot of things along the lines of that.
And when you say they would say a lot of threats, who were those threats directed at?
Us, the police, sometimes even people in the crowd.
Do you have any idea why the people out on the street would make any threats to your group?
I have no idea.
Did you ever see anyone actually injured as a result of any of this violence that you've talked about?
No.
Did you see anyone shoot at anyone else?
No.
Did you ever consider using your gun to shoot at anyone?
No.
Was there a time in which you and the other members of your group observed people on the lot to the north of that location, which is marked on that map as St. James Church? Was there a time when you saw that?
Yes.
Okay. And could you just use your laser pointer and point at that St. James Church for us, please? Okay, and that's on the north side of 59th, on the northwest corner of 59th and Sheridan. Is that right?
Yes.
Yes, 59th. Now, on this map, which is a printout from a satellite, there's a structure there next to St. James Church. Was that structure standing on the night of August 25th, 2020?
No.
What was the condition of that lot?
A bunch of rubble and concrete blocks.
Now, I asked you about whether you saw folks on that lot, and I believe you said you did. Is that right?
Yes.
What did you observe about those people?
They were obviously hiding. It was pitch black outside. We couldn't see anything besides a lot of shadows hiding behind the rocks.
What action, if any, did you and the other members of your group take as a result of seeing those people hiding?
We all started yelling, telling them to stop hiding and to go away.
Did you take any physical action with your gun towards them?
We were ready in case they did have guns.
And when you say you were ready, what exactly did you do with your gun?
We had aimed them.
You would point your gun at those people?
In the direction.
Did the defendant do that?
I'm unaware.
You didn't see the defendant point his gun at those people?
No, I was looking at the construction site.
And you said you saw people hiding and you didn't know whether they had guns or not?
Not until the very end.
What did you see in the very end?
As soon as they did come from hiding, they started running, and I noticed one of the people did have a gun.
What type of gun?
It looks like a similar weapon to the one me and Kyle had.
When you say you saw them running, where were they running?
They were running, I want to say west towards the lake across Sheridan.
And you said it was dark. You said you eventually saw them with a gun. When they were in that lot north of you, did you see anyone point a gun at you?
No.
Did you see anyone with a gun at that particular moment?
No.
Did anyone fire any shots?
No.
And I believe you said earlier, during this entire evening, you stayed up on the roof the whole time.
Yes.
Did you ever get down and wander off that 59th Street lot to go anywhere else?
No.
We have heard in this case, after the fact, that there were some individuals out on the street that night whose names are Anthony Huber, Joseph Rosenbaum, Gage Grosskreutz. I assume as you sit here today, you're familiar with those names.
Yes.
On that particular night, had you ever met any of those people before?
No.
Did you know any of their names?
No.
Have you since seen photographs of those people so you know what they look like?
Yes.
Thinking back to that night, Did you see any of them?
No.
Do you have any memory of seeing Joseph Rosenbaum that night?
No.
Do you have any memory of seeing Anthony Huber that night?
No.
Do you have any memory of seeing Gage Grosskreutz that night?
No.
Now, I asked you a little bit about what you observed of the crowd on the street in front of this location. Where was the defendant when that crowd was going by? Do you know?
Around the Ultimate gas station.
Was there a time in which the defendant was at 59th Street when there were protesters out in front of that location?
59th Street.
Your car source location?
I want to say previously right before.
Right before what?
Right before they had got to us.
Okay. What, if anything, did you observe the defendant doing during that time?
I noticed that as soon as they did get to us, there was somebody that was hurt, and he went and helped them and brought them back into the building. And then as soon as they were all like bandaged up, he brought them out.
Do you know what sort of injury they had suffered?
I do not.
And when you say you saw them go into the building, did you actually see with your own eyes them enter the building?
Yes.
Okay. And the supplies that the defendant had in his medic bag or something, did those all come from your residence?
Yes.
Now, there came a time in which the defendant was involved in some shootings that night, and we know that. What I want to ask is, what do you remember about that time period that we now know was the time of the shootings?
I remember that one of us had received information that one of the car source dealerships was being vandalized, or people were trying to burn it down. Kyle was not able to make it back to us, our location, so either me or Nick called him and told him about what was happening, and then the last I saw of him was him running towards that direction, and then from then on I just heard gunshots. Now, you said you heard some information about the 63rd Street car source. Where did that information come from? I'm unaware of that. And you said somebody received that information. Do you recall if that was you personally who received that information? I don't exactly know if it was me or Nick. And you said somebody contacted the defendant. Was that over the phone? Yes. Do you recall who that was? I do not. You've given a statement about this night already to the police, is that right? Yes. And you and I have talked previously with your attorney, Mr. Cotton, who's in the second row with the purple tie, about this situation, right? Yes. At no point did you mention to the police that you were the one who called the defendant. Is that correct? Yes. And at no point have you mentioned in our meetings that you were the one who called the defendant. Is that correct? Yes. You said you saw the defendant heading down, and then you heard some gunshots. What is the next thing you remember about the defendant after that? I didn't believe the gunshots were actually his until I got a phone call. And I answered it, and he just said, I shot somebody, and then hung up right away. When did you see him next after that? I want to say just a few minutes right after that. Was that back at 59th Street? Yeah, that was at the original location. What observations, if any, did you make about the defendant when you saw him? He was freaking out. He was really scared. He was pale, sweating a lot. You could tell he was just scared. Did he say anything? He wasn't really talking. He just said he had to do it. It was self-defense. People are trying to hurt him. Did he ever say to you that someone was trying to attack him with a gun? No. Did he ever say to you that someone was trying to attack him with a knife? No. Did he ever say to you that anyone was trying to attack him with any sort of weapon? No. What happened after that? After that, we kind of all tried to calm him down. There was some people yelling, but we kind of made the idea that he should turn himself in, but we couldn't do it in the one in Kenosha because there's people rioting at the front doors. So I took him home, and then we decided he should go turn himself in at the nearest police department. When you say you took him home, did that mean you drove back down to Antioch? Yes. When you got down there, was anyone else at the defendant's residence? No. How long was it before anyone came back? I want to say 5 to 10 minutes. And who all came back at that point? The rest of his family. And that would be his mother and his two sisters? Yes.
Was there any discussion at that time about what the defendant should do?
Leave. Get out of town.
To where?
One of their family's properties in either Michigan or West Virginia.
What was your reaction to that?
Said no, he should turn himself in.
Were you urging the defendant to not flee, but instead to go turn himself in?
Yes.
Did he follow your advice?
Yes.
A couple more things, Mr. Black. Do you know what the defendant's occupation was around the time of August of 2020?
A lifeguard at the Rexplex.
We've seen some videos. I'll represent to you that at various points on that evening, the defendant tells people that he is an EMT. Do you know anything about that?
I know he has some training in that type of field, but that's kind of the most of my knowledge.
Do you know whether he had ever worked as a paramedic?
No.
Do you know whether he'd ever worked as an EMT?
No.
Now, you have talked about the fact that there was an understanding between you and the defendant that because he was 17 years old, he could not legally possess a firearm. Is that correct?
Yes.
The jury has been told, I'll represent to you, that there's a charge against the defendant in this case for possession of a weapon by someone under the age of 18. Has the person who provided the gun to the defendant, which was used to kill other people, are you facing criminal charges?
Yes.
In fact, have I not personally drafted a criminal complaint against you, charging you with 2 felony counts of providing that gun to the defendant, which were used to kill 2 separate people? Is that correct?
Yes.
And that is a case, a criminal case, that I'm prosecuting that is still pending. Is that right?
Yes.
As a criminal defendant in that case, are you aware of the fact that you have a Fifth Amendment right to remain silent and not answer any questions about any of that?
Yes.
Have you decided today to come in front of this jury and tell us the truth about everything?
Yes.
Despite your Fifth Amendment right?
Yes.
Have I made any promises to you about what might happen in your criminal case in exchange for your testimony today?
No.
You have an attorney here, Mr. Cotton, who is your attorney in that case. Is that right?
Yes.
I want to confer, see if there's anything else I wanted to cover. Just a couple more things, Mr. Black, that I've neglected to mention. You mentioned that you observed that the defendant was pale and sweaty, I think you said freaking out when he came back from the shootings that night. Is that correct?
Yes.
Did you see any injuries on him?
There was some red marks on his head, but besides that, no.
Did he say anything to you about any injuries that he suffered?
Just that his head hurt.
Finally, at one point in the evening, there's some indication on some videos that there might have been some folks behind the 59th Street car source, maybe throwing some rocks or something like that. Do you remember anything about that?
Yes.
What do you remember about that?
Out of nowhere, there was like people behind us in the neighborhood throwing rocks at us on top of the roof.
What, if anything, did you do about that?
I tried to dodge them.
You had a gun, correct?
Yes.
Did you think about using that to defend yourself?
No.
Why not?
So they were just rocks. I mean, they were throwing them from a distance, so I didn't really feel like I was in like great bodily harm or being hurt.
Do you remember if the defendant said or did anything in reaction to those folks?
No.
I have nothing further.
No,
Thank you.
he didn't, or no, I don't remember.
No, he didn't.
I have nothing further. Thank you.
Cross-examine?
We need a bigger podium. Space. Dominic, excuse me, Mr. Black, I apologize. You knew Kyle Rittenhouse through his sister, Mackenzie.
Yes.
And when you were 18, 19, you were dating Mackenzie.
Yes.
And you and Kyle were good friends.
Yes.
And you referred to each other as brothers.
Yes.
Okay. And you talked about Kyle taking the gun out of your father's basement without permission. Do you remember that?
Yes.
And so up until that point, according to your testimony, you knew nothing about Kyle taking the gun down to Car Source that night.
No, I was definitely aware of it. I kind of never really went into that inside my mind. I never really clicked that, you know, like, hey, he shouldn't have that.
No, what I'm getting at is whether it clicked at that point or not, it's your testimony to these 20 people from Kenosha County that you didn't know about it until he brought it up from the basement on August 25th.
Oh, yes.
You agree with that statement?
Yes.
Okay. Then, can you tell me why earlier in the date you guys did go to Jelensky's, correct?
Yes.
You drove to Jelensky's.
Well, this was after he had brought the gun up.
That's not what your testimony was on direct examination.
That's how it went.
Okay, so he brings the gun up, you go to Jelensky's, and then go right downtown. That's what your testimony is on cross-examination.
Yes.
Okay. Whose idea was it to go to Jelensky's?
I don't recall.
But you said Kyle went into Jelensky's alone.
Yes.
And you don't know why he was going into Jelensky's?
I knew why he was going in there.
Okay, why?
To get a sling.
Okay. And then out of the goodness of his heart, he bought you one?
The plan was for both of us to get one.
Okay. So you knew he was going there to get slings, correct?
Yes.
You didn't tell him not to bring the gun, correct?
No.
Now, Kyle Rittenhouse's gun this is your gun, correct?
Legally, yes.
And this is an optic on the top of that gun, correct?
Yes.
This optic, does it shoot a laser beam out of it?
Not out of it. I mean, it projects one inside of it, yes.
Right. But if I were to point this gun, and obviously I can't do it here in a courtroom, but if I were to point this gun at you from here, there would be no red or green dot on your chest.
No.
This is the optic from Kyle Rittenhouse's gun. Do you need to see it?
No.
Do you agree that this is?
Yes.
This does not project a laser dot on you either, correct?
No.
So if someone said Kyle Rittenhouse put a laser from his weapon on their chest, that's impossible, correct?
Correct.
Now, Mr. Binger asked you about the charges that you currently have pending against you, correct?
Yes.
And those charges are a result of you providing the gun to my client.
Yes.
And each of those is punishable by 6 years in the Wisconsin State Prison, correct?
Yes.
And you're testifying here today, hoping that Mr. Binger will give you consideration on those charges and not send you to prison, correct?
Yes.
And you just...
Well, to be precise, Mr. Binger can't send him to prison. Mr. Binger can prosecute him, and a judge could send him to prison if he's found guilty.
Mr. Binger can make a recommendation of prison.
True. And yes.
Mr. Binger can make a recommendation of prison, correct?
Yes.
And you're hoping that by you testifying, he doesn't make a recommendation of prison, correct?
Yes.
Probation.
There's no really assuming what I get out of this.
There haven't been any promises made. I'm asking you what you're hoping.
I'm hoping for whatever the best is I get. I don't know what it is.
Okay. Your attorney, Mr. Cotton, he's met with you and Mr. Binger and the detectives?
Yes.
When's the last time you guys met?
I want to say a few days before this date.
You didn't meet today?
Well, I mean, yeah, we did meet today.
When's the last time before today? Last week sometime?
Yeah.
Okay. You're aware that I asked your attorney if you'd be willing to meet with me, correct?
No.
No? On August 26th of 2020, you were at the Antioch Police Department when Kyle turned himself in, correct?
Yes.
And you were interviewed in the early morning hours of August 26th by, I'm fine, Detective Antaramian.
Yes.
And he's the individual who's the second from closest to the jury, correct?
Yes.
You met with him for a little over an hour?
Yeah, it was well over an hour.
And that was when everything was fresh in your memory, correct?
Somewhat. I was very tired.
But it's much nearer in time than it is today, correct?
Yes.
And you told him on that date, it was audio and videotaped, what you remember, correct?
Yes.
Do you remember talking to Detective Antaramian and telling him whose idea it was to go to Car Source to protect the property?
Yes.
Was it, I'm going to give you three choices, yours, Kyle's, or Nick Smith's?
Nick Smith's.
When you got to Car Source, after you'd stopped at Jelinski's, you meet with Nick Smith?
Yes.
And you knew that Nick had worked at Car Source?
Yeah.
And he introduced you guys to Sam and to his brother?
I wouldn't say introduced. We had met Sam previously that day, but his brother we had not met. Sir, I'm showing you what's been marked as Exhibit Defendants 30. Can you tell me what that is? This is the second location we went to when Sam, I don't remember if it was Sam or his brother, had given us a ride, me, Kyle, and Nick, to the location that would be more north. And that's where we met up with a lot of people that we really didn't know.
Okay, that would be Car Source at 63rd and Sheridan.
The one right down here.
Right here.
Yes.
Sheridan and 63rd.
Okay.
Right?
Yes.
The far right of that photograph, who is that depicted in the photo?
The far right?
Far left, where I'm pointing, I'm sorry.
The co-owner of Car Source?
So is that Sam or is that his brother?
I believe that's his brother.
Okay. Where are you in this picture?
The far right.
The far right?
Yes.
Who's standing next to you?
Kyle.
And what's in front of Kyle's feet?
A first aid box?
Okay. That's a first aid box that is different from his first aid pack that he wears on his side, correct?
Yes.
Where is Nick Smith in this photograph?
He is 2 people to the left of Kyle wearing the white hat.
Okay, so he's got a white hat with a cross on it? Yes?
Yes.
Now, you know the owner, you know Nick, and you know Kyle. Everybody else in that photograph, had you ever seen them before that day?
No.
Did you have any plan of ever meeting up with those individuals to help protect CarSource?
No.
They just came along when you were at CarSource and offered their services to help, correct?
Yes.
Does the name Ryan Balch mean anything to you?
Yes, it's somewhat clear.
Okay. And who is Ryan Balch today to you?
I never really got to meet him a whole lot. He is one of the people that showed up randomly or unexpectedly.
And you talk about you wanting to be on the roof, correct?
Yes.
You told Nick Smith you wanted Kyle to be on the roof, correct?
Yes.
And Nick Smith said, no, we wanted Kyle on the ground.
Yes.
Because he's a medic and he can provide services, correct?
Yes.
You saw Kyle fix somebody's hand who had a big gash in it.
Yes.
You saw him give aid to a woman who had been shot by a gas ball.
I'm unaware of that.
Okay. You saw Kyle going out with other individuals in that picture, Exhibit 30, and put out some fires, correct?
Yes.
And did you see anybody that evening starting any fires?
Plenty of people.
Plenty of people starting fires?
Yes.
Did you see the individuals who took the trailer from the lot of rubble, put it out in the street and started on fire?
I did not see that.
You didn't watch that?
No.
Weren't paying attention?
I don't know if I don't remember or if I missed it.
Okay. What about the porta potty?
Yes, I saw that.
Okay. Describe that.
People were tipping over a porta potty and lighting it on fire.
Okay. And you can't, as you sit here today, say who did that, but you know what happened.
Yes.
Okay. And you don't know what Mr. Rosenbaum did or didn't do because you weren't paying attention to him.
Yes.
You don't know whether Mr. Rosenbaum, let me ask it this way, simpler. You know of nothing that happened down at the 63rd Street and Sheridan Road CarSource?
No.
Couldn't see it?
No.
Even though you're on the roof?
Yep.
Now, I'll answer it this way. Kyle's phone records have you calling him and sending him down to CarSource 3. You don't dispute that, do you?
I don't remember it.
I'm not, if his phone records say he got a phone call from Nick Smith, you don't dispute that?
Not exactly, no.
Okay. And the whole idea was to send Kyle down to CarSource 3, the 63rd Street CarSource, because you guys had received a report that the people who were supposed to be protecting it had left, correct?
Yes.
And the property was being destroyed.
Yes.
You didn't know that Kyle had been separated from Mr. Balch at that point.
I did not.
So you tell him to go down there and protect that property because the cars are being bashed in, correct?
Yes.
It was either you or Nick Smith.
Yes.
And from where you were, you could see Kyle going down in that direction.
Yes.
And it wasn't the second he goes down there you hear shots. He goes out of your view, there's a fairly lengthy period of time, you hear a gunshot, and then you hear a series of more gunshots, correct?
Yes.
And you, from where you were, could not see what happened to Kyle at the second incident, correct?
Yes.
Did not see.
I did not see.
And eventually, Kyle comes back in to your vision, correct?
Yes.
What did you observe Kyle doing as he approached? Well, let me ask you this. Where was he first?
Where I first saw him was kind of against a tree line. It was more in front of the Ultimate gas station. And I saw him walking with his gun hanging down and he had his hands up. And then I watched him walk up to a police car and then step away.
Okay.
And then...
Describe what he's doing as he's going up to that police car.
I can't hear anything, but I could tell he was yelling.
Okay.
I don't know what he was yelling.
Where were his hands?
In the air.
Okay. And you saw him walk up to the police car?
Yes.
You don't hear anything, but does Kyle stay and go up to the car? What's his next movement?
He walks up to the car and very quickly he jumps back.
Okay, like somebody told him to get back?
Yeah.
Because he walked up there voluntarily, correct?
Yes.
And then he quickly steps back.
Yes.
And he then makes his way back to car source number 2, correct?
Yes.
And he goes to that location, you guys meet up outside, you come down the ladder.
Yes, I come down the ladder. By the time I had got inside the building, he was already sitting in there.
Okay.
So they had to open the doors for him and let him in.
Okay. And you described him on August 25th, the morning of the 26th, I apologize, to Detective Antaramian as sweating like a pig. Do you remember using those words?
Yes.
White as a ghost?
Yes.
And hysterical?
Yes.
He told you he shot somebody?
Yes.
Told you he had to shoot somebody?
Yes.
With self-defense?
Yes.
Hadn't met with a lawyer, correct?
Correct.
Hadn't talked with anybody about his story. He's telling you right that day what happened.
Yes.
And you don't want to take him to the Kenosha Police Department, correct?
Yes.
Why not?
It's impossible.
You can't get to it,
Yeah,
correct?
you can't.
And if you guys walked up there with guns, you'd be a target, correct?
Yeah.
And you agree to go home to Kyle's residence, and he'll turn himself into the police there.
Yes.
And he did turn himself into the police.
Yes.
An hour and a half after you finally saw him at the car source, correct?
About that time, yes.
1:20 a.m. That's what the video shows. You don't dispute that.
No.
And you talk about discussions whether or not he should leave. That was his mother who was making those discussions, correct?
Yes.
Kyle wanted to turn himself in, correct?
Yes.
Yes?
Yes.
And he did.
Yes, he did.
And eventually you were asked to come down to the police department, correct?
Yes.
And when you were asked to come down to the police department, you brought the guns.
No. The police had met us there at the apartment, and then they took them.
Okay. And then you drive then down to the police department.
Yes.
With Kyle's 2 sisters.
Yes. No. Yeah, I believe so.
And shortly after you get there, that's when that first interview happens with you, correct?
Yes.
And at that point, you are worried about the fact that you had given Kyle the gun, correct?
Yes.
And you talked to your girlfriend, his sister, at the police department and asked about coming up with a story to protect you regarding the guns, correct?
I do not remember that.
If she said it happened, you wouldn't disagree, correct?
I would disagree.
Okay. And Detective Antaramian asking you a question on the morning of the 26th. So when did you first see the gun? You. About when we were getting into the car, when we walked outside the house. Detective Antaramian. Okay. Did you talk to him about it at all? No. I had a lot of stuff on my mind. Do you remember that exchange?
Yes.
Okay. Nothing bad had happened at that point, correct?
Correct.
So what did you have on your mind that was interfering with you saying, hey, Kyle, don't take the gun?
Kind of scared to go down there, not knowing what to expect.
Just, you wanted Kyle to have the gun, correct?
That wasn't really an opinion in my mind at all.
You wanted a gun.
Personally, for myself, yes.
You had no objection or voiced no objection to Kyle, your brother, having the gun, correct?
It wasn't a thought in my mind.
Well, he walks out of the house with an AR-15, and you don't say boo, correct?
I didn't say anything, correct?
And you have the ability to speak.
Yes.
If you wanted to object, you could have said something to Kyle, correct?
Yes, I could have.
And you didn't.
No.
Because you wanted him to have the gun for protection.
Not that reason exactly.
You wanted a gun for protection.
Yes.
This is a statement that you made to Detective Antaramian on the morning of the 26th. But that's what I knew of it. Basically, we go down there and we walk up, and it's coincidental. We walk up and there's Sam, and I'm like, oh, Sam, I just met you not long ago or whatever. And he gives Nick keys to the building and showed him where the ladder was, correct?
Yes.
You guys had permission to be there?
Yes.
He wanted you to protect his property.
Yes.
And he wanted protection at the 59th Street address and the 63rd Street address.
Yes.
And once you found out there wasn't any protection at the 63rd Street address, you sent Kyle down there, correct?
Yes.
And initially, Nick was acting like he was in control of everything, correct?
Yes.
And he was leading the people from the West Bend area who you didn't know, like he was even the owner of Car Source, correct?
Yes.
He wasn't, correct?
No.
Do you remember telling Detective Antaramian the only person I saw actually help people was Kyle?
Yes.
Because he was, correct?
Yes.
He might not have been a trained EMT, but he was providing first aid.
Yes.
And that big orange box in Exhibit 30 that I showed you, that was the stuff he brought from either his house or his employment, correct?
I'm not too sure where that came from, if I'm being honest.
Do you remember telling Detective Antaramian the only person I saw actually help people was Kyle?
Yes.
Because he was, correct?
Yes.
He might not have been a trained EMT, but he was providing first aid.
Yes.
And that big orange box in Exhibit 30 that I showed you, that was the stuff he brought from either his house or his employment, correct?
I'm not too sure where that came from, if I'm being honest.
Water bottle, and then poof. Detective Antaramian, what hurt? Did the bottle hit you? You. No. It was actually, I was on the roof, but the wind was blowing towards me, so it was a bunch of just like a tear gas bomb. Just a bunch of smoke in the air. It came towards me, and my eyes started to burn. Do you remember that?
Yes.
So they were throwing gas bombs at you on the roof.
Yes.
There were gas bombs on the ground.
Yes.
Now, do you remember talking to Detective Antaramian about somebody on the roof who was upsetting you because he was taking a laser pointer, not on a gun, but a laser pointer and pointing it at people?
Yes, I do remember.
Okay, that wasn't Kyle, correct? Because he was never on the roof.
Correct.
Now, who was that?
One of the people that came from out of town. He was about in mid-30s, I want to say mid-40s. He was on the...
Is he depicted in Exhibit 30? If you have to walk closer, go ahead.
I don't think I see him. No, I don't believe so.
But it was a laser pointer, and the individual would point to demonstrators, rioters, correct?
Yes.
That upset them?
Yes.
Because it was pointing them out?
Yes.
And it also upset them because they could have thought it was a weapon?
Yes.
And you told him to stop?
Yes.
And he just kept laughing about it?
Yes.
Detective Antaramian asking you on the 26th, okay, anyone have inaudible? Kyle, he disappears out of view. You. Nick somehow finds out that there's nobody there and there's people trying to break cars. And he tells Kyle and the other dude that he was on the ground with to go over there. So did he tell him this in person or on the phone? Phone. Do you remember that?
It was on the phone.
But you're not sure who called?
Yes, I'm not sure.
Later on in that same interview, you speaking. He was actually on the roof at that point. Nick kept on going up and down, up and down. He called Kyle. Before he called Kyle, he told me, like, there's nobody there. They're trying to set cars on fire. I was like, oh crap, oh crap. And he called Kyle and he tells him, and then Kyle starts running and he bolts for it. Do you remember telling the detective that?
Yes, no, I do.
And you stated you saw him run from the gas station, correct?
Yes.
Could you see the fire extinguisher in his hands?
Yes.
Because you're only, if you're on the roof of the car source number 2, you're like 1 block from 60, not 1 block, less than a half a block from 60th and Sheridan Road, correct?
Yeah, that's pretty accurate.
You had a clear line of sight directly to the ultimate gas station.
Yes.
Detective Howard, to you on the 26th. What makes Ryan supposed to be with Kyle? Why do you say that? I wouldn't say supposed to, but they were with each other the entire night. Every time Kyle left, so did he. So they were always together.
Yes.
And when they're going out to provide medical attention to people, they're going out with the buddy system. Is that a fair statement?
Yeah, that's fair.
And when Kyle would go out and put out fires that were going on, he would go with somebody else, the buddy system, correct?
Yes.
There was a time where he left with the female, Joanne Fiedler, with the white helmet, and went and put out a fire by the church. Do you remember that?
I believe so.
And you stated, so I figured they wanted to team up and go out and help people,
Yes.
telling the detective. This is Detective Antaramian questioning you on the 26th, asking you if you remember this. Okay, so then at some point you guys, so I mean, I guess, and I'm not trying to make you look worse, but I want to make sure I'm factually accurate here. I mean, the fact that he buys this sling for his gun, it's likely he's going out to take it with him that night. Well, the intent was to buy a sling for me. Do you remember that exchange?
I do not.
But even Detective Antaramian questioned you about the sling and the timing of it, correct?
Yes.
And how hard was it to attach those slings?
I don't really recall.
Do you remember the detectives wanting your telephone?
My phone?
Yeah.
No, I don't believe so.
Didn't they talk to you? And I'm reading from Detective Howard at that same interview. So we're just going to apply for a search warrant. But absolutely, as it's laid out in that form, you have the right to refuse. Dominic Black. Okay, so I'm not understanding as far as what I believe. I believe I'm going to be here for a while. Okay? And I have not talked to the authorities yet, so I don't know. Do you remember the discussion about that?
Yes, I do.
Okay, and they wanted to download your phone, correct?
Yes.
Yes?
Yes.
And eventually you said to him, fine, you can download my phone, I don't have anything to hide.
Yes.
Now, yeah. And that interview regarding the incident regarding your phone, and I'm sorry if I misled you, that was the November 6th incident, correct?
Yes.
Okay, and at that point, you were already under arrest.
Yes.
And the detective both detectives interviewed you that night.
Yes.
And when you were in that interview, as it was wrapping up, they told you to have your lawyer, who was a different lawyer than Mr. Cotton at the time, reach out to Mr. Binger. He needed to talk to him about working something out.
Yes.
Okay. And from that day, they wanted you as a witness, correct?
I wouldn't necessarily say from that day, no.
Okay. Your trial on your charges was set back in September, correct?
I don't exactly recall.
Let me ask it this way, not trying to trip you up on dates. Your trial on these charges, which Mr. Binger is prosecuting you for, was before today.
Yes.
Okay, about a month and a half ago?
Yes.
Okay. And you, your lawyer, and Mr. Binger walked into this courtroom and asked that the matter be set over until January of 2022.
Yes.
After you testified here today, correct?
Yes.
Before August 25th, 2020, that gun that Kyle Rittenhouse possessed on the night in question had never left the state of Wisconsin, correct?
Correct.
And you guys had the gun and you took it to Illinois so he could turn himself into the police.
Yes.
And you and Kyle did the taking off graffiti, correct?
Yes.
And that was in the late morning, right around lunchtime of the 25th, correct?
Correct.
And in that photograph is you, your stepfather, and your girlfriend, Mackenzie, correct?
Which photograph?
The photograph of this photograph right here.
My stepfather isn't in that picture.
He's not in that one?
No, it'd be my brother, and then Kyle and Mackenzie.
Okay, so you are where?
That might have been when I left to go get like the sandpaper.
Okay. And Kyle's wearing the olive green shirt with his hat turned backwards?
Yes.
And who's that standing next to him?
Mackenzie?
Okay. And you guys had spent the night before at your dad's house, correct?
I'm not aware of where he slept. I don't really remember.
Could have slept at your house?
He could have.
Okay. And Mackenzie slept at your house that night?
I'm not aware. I can't remember.
Do you remember watching live streams of the riots?
No, I do not.
Did your dad talk to you about the riots and that's the reason he got the guns out?
He did previously that night, yes.
Do you remember him talking to you as you told the detectives that there was a plan to board up the windows if the rioters came?
Yes.
Okay. So all that was going on, you're aware of it?
Yes.
And when you guys are target shooting up north, there was nothing strange about that, correct?
No.
Kyle handled the gun appropriately?
Yes.
And he shot at those small little, you're saying clay pigeons?
Yes.
About 4 inches in diameter?
Yep.
You shot at the same things?
Yes.
Nothing out of the ordinary?
No.
I have nothing further, sir. Thank you.
Redirect.
I want to pick up where that left off there. It sounds like there was a plan with your father to have the guns available, board up windows to protect the house that you live in. Is that right?
Yes.
But you decided on the night of the 25th to leave home and go downtown to protect car source. Is that right?
Yes.
Why didn't you stay home? Protect your house.
The riots had been going on for a while. The house had been ready to be boarded up. All the guns have been out for, I want to say, ever since the riots started, and nothing happened. I felt that the house would be safe.
The timing of all this, if I understand you correctly, is on Tuesday afternoon, late afternoon, 4 o'clock or so about, is when you and the defendant take the guns from your house and come downtown.
Yes.
Is that about right?
Yes.
You were somehow aware of stuff that had happened on Monday night and on Sunday night, right?
Yes.
That's part of the reason why you went downtown.
Yes.
But you decided at 4 o'clock on Tuesday afternoon there was no danger to your house that night?
I mean, I kind of figured, I mean, it's not just me that would be staying at the house. I have a lot of brothers that live there. It wasn't entirely my responsibility to make sure that the house was safe. I mean, I felt that it was safe. Nobody was going to harm the house. Nothing in the area had happened.
Okay. On this particular evening, when you're at the car source at 59th and you're up on the roof, where was Nick Smith during that evening?
He was up and down. So he was on the ground, he was on the roof, he was inside the building.
Did he ever have a gun that night?
I believe so. To the best of my memory, I think he did.
Do you remember if he had it the whole evening or just a short period of time?
I don't remember.
Is it fair to say that Nick Smith stayed at that location physically the whole night?
Yes.
And you did too?
Yes.
You've been asked by me, you've been asked by Attorney Richards, several variations of the same question, and I don't know that I think we've done some...
Don't comment on the witness's answer.
Who told the defendant to go to 63rd Street Car Source?
I'm not 100% certain.
At any point that evening, did you personally receive information from any other person that there were problems at the 63rd Street Car Source?
The only person I figured that out from was Nick Smith.
Do you know where he got that information?
I do not.
To your knowledge, did he physically ever go down to 63rd Street after you got to 59th, you know, when you finally got all set up? Did he ever leave later in the evening to go check and see what was happening at 63rd Street Car Source in person?
No.
You said at some point in the evening, someone up on the roof was using a laser pointer to aim at the crowd. Is that right?
Yes.
Okay, thank you. So we're talking about something like this, shining it on a person. Is that right?
Yes, but a lot bigger.
Okay. Was it your understanding that the people who had this pointed at him felt like that was a gun?
Yes.
Pointed at him? You're telling us that it wasn't actually a gun, but the people on the ground thought it was.
Yes.
And you were upset by that?
Yes.
Why?
Because he shouldn't be doing that. There's no reason for it. And it's drawing attention towards us.
Did you feel that it wasn't appropriate for anyone on the roof or on the ground to be pointing a gun at anyone?
No, I didn't really feel like that was necessary at all.
Maybe I misstated my question. Let me just make sure I'm clear on that. Would you agree with me that it was not appropriate for the members in your group to be pointing their guns at people?
Yes.
Okay. You mentioned earlier, when I was asking you questions, that someone was throwing rocks. You said in response to Mr. Richards' questions that someone was throwing some sort of water bottle or gas bomb up on the roof. Is that right?
Yes.
When these folks were doing these things to you and the other members of your group, did you point a gun at anyone?
No.
Did you fire at anyone?
No.
Why not?
Because there's no need to. I mean...
Did you feel that by these people throwing rocks at you or throwing a gas bomb at you, that you were in danger?
I mean, pain, yes, but not danger. I knew it wasn't going to kill me.
So you felt like it wasn't enough to use deadly force?
Correct.
You were asked some questions about the discussions that you and I have had during the lead up to this case. Have I ever put any words in your mouth?
No.
What was the number one rule that I told you that I wanted from you when you testified?
Nothing but the truth.
Final question I have for you. Those slings, you were asked about how hard those slings were to attach to your body, and I forget, what did you say about that?
I don't truly remember.
Once they were attached to your body, did they hold that gun sort of dangling in front of you?
Yes.
Could we show that photograph of them? I think it's number 30, the one you just used. Okay. Yeah, I'll hold it. That's okay. I'm going to show you, Mr. May I approach on it? I've got this photograph that you've already seen. It's exhibit number 30, and it's showing you and the other individuals at the 63rd Street car source. Is that right?
Yes.
Are you wearing the sling in that photograph?
Yes, it appears.
And is that sling holding that gun in the front portion of your body?
Yes.
Does the defendant have his sling on with his gun being held similar to you?
Yes.
Was that sling strong enough to hold the weight of that gun?
Yes.
Was that sling strong enough so that if someone tried to pull that gun away, the gun would be held to your body?
Yes.
I have nothing further.
Can you redirect, or recross rather?
I would move Exhibit 30 into evidence.
Is there an objection?
No.
Received. You may step down, sir. Let's take a break. Let's aim for about 20 after. Please don't talk about the case during the break.
Okay, well, there we go. That is session 2 of the day. And how did it go? Oh, Julie's back. Hi, Julie. Yay. Okay. Hello to everyone again. Man, what a I feel bad for people who have to be under the scrutiny of lawyer questions. You know, that's tough. That's a tough one. Come on. So, oh man, there was so much stuff. There's so many details, you know, they ask the craziest questions, and sometimes I have no idea where they're going with them. Lines of questioning don't necessarily make sense to me. Just recently, he was hammering the point that after the incident, and he spoke with Kyle, he was saying that he was like really hammering the point that Kyle didn't specify that people were coming after him with either a gun or a knife or any weapon of any sort. He was likely in a state of shock. Like, you don't, I mean, we see this even with like people who are in very high intense jobs, police officers, military. Sometimes your memory of what happened doesn't come back fully until you've had time, your adrenaline settles down, you know, and you've had time to really address what took place. You know what I mean? So wait, what? Oh, okay, you guys are talking to Crystal. I'm assuming you're joking. I did not see that happen. So Kyle was likely in a state of shock. I can't believe that the lawyers would hammer so hard that he didn't provide specific details about the incident when he was still probably just trying to process even what just happened. I mean, I can't stand lawyers in that aspect. You know, I don't really can't stand lawyers in general, but and so the first witness is actually Dominic Black, who is being charged as well. Like, so he's coming under charges for this incident as well, for providing a firearm to a minor that resulted in a death. So that's probably a pretty heavy charge that he has on him as well. And so it sounded to me like he's trying to get a couple of things to happen, maybe some, like a plea deal for testifying, or maybe to see what happens with Kyle so that his, the baby is messing with the camera. Rain, come here. The baby is messing with the camera. Something along those lines. Come here. Okay. And you know, I also commend Dominic. I think he did really good on the stand. There was that one moment where the lawyer was asking him if he remembered something happening, and he said no, he didn't recall. And he said, "Well, your sister said it happened." And he says, "Okay." And the lawyer said, "But if your sister says it happened, you wouldn't disagree?" He's like, "Yeah, I would disagree." Like, just because my sister says it doesn't mean it happened. I commend him for standing his ground and not letting the lawyer bully him around. That was really, really commendable. Because, you know, these lawyers and the things that are going on, they're trying to win. And we see that they will take whatever avenue that they can. So I wasn't completely tuned into the entire thing because I got other things going on around here. I mean, since the boys are gone, I'm trying to get a couple things done that I wouldn't be able to do if I had a house full of rambunctiousness going on. So so that's what's happening now. Baby underfoot. That is exactly what's happening. Okay, here she is. She finally made it to this side of the desk. You gonna say hi? Huh? I bet. So I've seen several people that are showing the Kyle Rittenhouse trial, like Matt Walsh and CJTV and I don't know, maybe the Daily Wire. There's several people that are showing, the trial, and they have thousands of viewers. And I'm like, I bet none of them have a baby. Ours is definitely a special showing here. So that's how we're doing this. So if you're new here, please like, follow, subscribe. It's free to do so. Please share. And don't forget about the notification bell, because if we leave it up to Facebook and YouTube, they will set it to highlights or personalized, which means you'll get, we kind of depend on them to decide when to send out a notification. You want to make sure that you set it to all notifications so that you get every notification coming from the BC Preacher on Facebook, Twitch, and YouTube. Also, there's some new gear in the store. Let's Go Brandon. I've actually added some extra. Let's check it out. Everything woke turns to Let's Go Brandon, because we love Trump saying everything woke turns to beep, which I absolutely love, because he's absolutely right. This Terry sweatshirt, this women's Terry sweatshirt, super, super comfortable. And Let's Go Brandon Ditch 46. So you can find those things in the store at onamericanstreets.com or thebcpreacher.com. So yeah, if you're new here, guys, thanks for hanging out with us while we watch the trial. They're currently in recess right now, so I didn't hear them actually go into recess. So I didn't hear what time they're going to be back. That's a problem. So I'm going to check that out. I'm going to put this on a hold screen until I kind of figure out what's going on. Oh, yeah, and aprons. Don't forget the aprons. I got my Let's Go Brandon apron. And I don't even wear aprons, but I will wear it to wear that Let's Go Brandon. So I know she'll never get a date. I can't say I'm mad about that. Thank you for keeping the chat open for free, not requiring to pay to interact with chat. Yes, thank you for keeping the chat, really copacetic. I mean, I appreciate the chat not being like just a war zone, which is super awesome. He said 20 minutes about 8 minutes ago. Thank you so much. You guys are awesome on Twitch. I appreciate you guys so much. So that was about 8 minutes ago, you said. 20 minutes. Okay. No, it is not easy being a mom and other things. Yeah, so we've got a lot going on. Witchy, I am just now breaking into the big package you sent, and there is so much going on in there. So, yeah. Say hi to everybody. Say hi. Say hi. Yay! Okay, so I will be back with you guys as soon as we go back live.
with his gun being held similar to you?
Yes.
Was that sling?
Yes.
Was that sling strong enough so that if someone tried to pull that gun away, the gun would be held to your body?
Yes.
I have nothing further.
Can you redirect or recross rather?
I would move Exhibit 30 into evidence.
Is there an objection?
No.
Received. You may step down, sir. Let's take a break. Let's aim for about 20 after. Please don't talk about the case during the break.